may I permit to mention one this correction one all tribal error in complete
Okay, to be mentioned.
Malad, may I have lost deep to mention one matter. If you make 271
Yes, for
Malad for Malad reconstruction, because Malad this appeal was disposed of by Lokadala and pursuant to the order passed by the Lokadala, the insurance company has deposited the check. Check is lying in the account data section.
okay, to be mentioned.
To mention for reconstruction.
Mentioning fresh contempt application for inclusion, my lord.
Contempt application
As
in
in out of my lord's order.
which matter?
My lord, it's read petition during the vacation bench. My lord was pleased to direct to give the benefit of rounding off in CRPF matters, my lord.
So have you filed that application?
Yes, my lord. We are praying for inclusion.
Yes.
4 matters are there.
My lord, may I be permitted to mention, my lord, this matter? My lord, we are for the respondents, my lord. The appellants, sole appellant died, but my lord, they are not taking any steps. Once your lordship gives us I will give notice.
No, you're for appellant?
I am for the respondent, my lord. My suit is being stayed in the court below.
Okay, let it appear as to be mentioned.
My lord, I shall give notice to the other side.
Lordship, item number 87 of today's list, Lordship. This
Yes.
matter is already settled between the parties, Lordship.
87.
87. I am
Okay.
to the respondent insurance company.
No, if it is settled means
Yes.
settled in the department.
No, it outside court with the.
Yes, yes. So let it be sent to Lok Adalat. You record
Yes,
that
yes,
settlement.
yes, yes. Kindly
Yes,
record.
item number 87, record an order.
My learned friend is for.
Yes, learned advocates for the parties are present. It is submitted by the learned advocates that the matters has been settled between the parties. Thus, this matter is referred to the National Lok Adalat to be held in the month of December
13
2025. So let it appear on 8/1/2026 for report of the Lok Adalat.
My lord. Our number.
My lord, I am for the appellant. Let be the matter fixed for hearing. Fix a date, my lord.
So let it first go to Lok Adalat, thereafter in the month of January.
No, my lord. Let it be fixed for hearing.
So
my
you see, prior to January, no matters will be included for hearing. So better try to settle before the Lok Adalat. If settlement fails, I'll take it up in the month of January. Yes, record an order. Learned advocates for the parties are present. It is submitted by the learned advocates that the matter is ready for hearing and the paper books have been filed.
Yes,
Stop.
my lord.
As this is a motor accident claim case and may be settled through the Lok Adalat, let this matter be referred to the National Lok Adalat to be held in the month of December. Let this matter appear on 7/1/2026 for report of the Lok Adalat.
My lord, may I mention one thing? I heard that my lord will not take any hearing case.
No, hearing, if it is 1 or 2 matters can be taken up for these 2 weeks, but no inclusion for hearing in this month, all in the month of January.
So today hearing will be held.
No, hearing matters will not be included this month.
Oh, this month.
Only in the month of January it will be included.
5, my lord, I am for the appellant, my lord.
Must say, let
It is
in this month fixed.
Anyway, let me see if I can proceed with the application. Thereafter, if time permits, I'll take it up.
Today is fixed 33 and 38. So it will be held.
Okay, let me see. Let me take up this application. Thereafter, I shall see.
my lord.
Item 5.
Item number 5, my lord. Paperwork has already been filed. It is a ready case for hearing, my lord. It may be fixed for hearing, my lord.
Yes, in the January it will be taken up. Prior to that, it will be sent to Lok Adalat.
All right, my lord.
Learned advocates for the parties are present. It is submitted by learned advocates that the matter is ready for hearing and the paper books have been filed. Stop. As this is a motor accident claim case and may be settled, the matter is referred to the National Lok Adalat to be held in the month of December 2025. Fix 6/1/2026 for report of National Lok Adalat.
So I am for the applicant lordship.
Item 7.
In this matter, I appear for the respondent claimant. Is a appeal by the
Appellant-এর নাম তো
company.
রয়েছে।
Whether do we approach before the insurance company for settle the matter, but they are not willing to settle. Paper book have been filed. Let it be fixed in the month of January.
Yes, Mr. Singh, it cannot be settled.
My lord, your lordship will refer it to Lok Adalat. We will give another try, my lord.
So you ask your client?
I'll ask my client.
Yes, record an order.
Your lordship kindly record that the paper book have.
Yes. Learned advocates for the parties are present. It is submitted by the learned advocates that the paper books have been filed and the matter is ready for hearing. However, as this matter relates to the motor accident claim case,
Paper book file করা আছে তার নাহলে এই paper bookটা নিয়ে নিন।
however, as this matter relates to motor accident claim case, the matter is referred to National Lok Adalat for the purpose of settlement. Let this matter appear on 7/1/2026 for report of the National Lok Adalat.
Matter will appear
7/1.
and the paper book already filed department.
I have recorded your submission. Paper books filed and the matter is ready for hearing.
Paper book today, one copy of paper book. Department has given 2 copies. I am filing my lord 1 copy of paper book. Your lordship kindly record one.
Okay, 1 copy of paper book which is filed by Mr. Bonik today be kept with the record.
তোকে paper book দেওয়া হয়েছে department থেকে।
ব্যাক সিট আছে।
Paper book এরকম।
এন্ট্রি নেই তো।
ঠিক আছে।
দেখুন।
7
Yes.
এখনো পাইনি আমি।
I am for the applicant lordship. It is a review application.
No, review application against whose order?
Lordship against the order passed by the Honorable Justice Shubhendu Samant.
No, you see, there is a bench constituted to take up the review matters of the judges who have retired. Probably there is a determination. You just check it up. A bench is already there to take up these review matters of the judges who are retired or transferred, whatever it is. Probably you see the list. I'm making it not today.
Not kindly release the matter, Lordship.
Okay. Learned advocate for the petitioner claimant. Learned advocate for the petitioner is present. As this review application does not relate to order passed by this bench, the matter stands released. The matter may be placed before the bench having determination.
My lord, item 8, my lord, it has come up at our instance, my lord. This appeal was disposed of by your lordship, my lord, last week, November 26, my lord. My lord, there were a few omissions, my lord, which we had pointed it out to your lordship. Perhaps, my lord, they have not gone down, my lord, in the type. My lord will kindly, my lord, come to page number 6 of my
Yes,
lord's
let me
order.
see the order.
Lordship.
Okay. Disposal date.
Disposed of, order. 8 number, judgment, just like judgment টা দিন। My lord, this appeal was disposed of. My lord, the claimants were made entitled to, my lord, 56 lakhs odd. If your lordship is kind enough to come to page number 6, my lord.
Page 6, yes.
Lordship, the penultimate paragraph. If
Yes.
may I read, my lord.
Yes.
Hence, this appeal is allowed. Is my lord there, my lord? Hence, this appeal is allowed in part. Judgment and award dated so and so passed by learned district judge is modified to the extent that respondent number 1 to 4 claimants are entitled to a compensation of rupees 56 lakhs odd, along with 6% per annum interest from the date of filing till date of disbursement. Other contents of order of learned trial court remain unaltered. My lord, now here, my lord, this the type has gone down as upon payment of rupees 40,000 to the respondent number 1, the balance awarded amount shall be distributed equally. My lord, here, my lord, before this, my lord, I had submitted before your lordship. My lord, the insurance company, my lord, has deposited, my lord, the amount, my lord, that amount, my lord, if it is mentioned here, it would be easier for my lord's officer, my lord, to take out, my lord, the money from that deposit and disburse it to the claimant. My lord, if lordship is kind enough to mention, my lord, the amount what I have deposited. My lord, insurance company, my lord,
See,
after lordship.
I think
Lordship.
I think one paragraph line is there, residuary, whatever they are entitled, they will withdraw.
My lord, but before that, my lord, your lordship will kindly record, my lord, what I have deposited, so that it is easier for my lord's officer.
And there is no liberty, my lord, liberty
my
may
lord-
be given to the claimant to withdraw
My lord,
the
that is secondary
awarded
part. My lord, I will
sum.
come to that also. My lord, first, your lordship will kindly, my lord, I have deposited rupees 92,58,750 before my lord's court. So if my lord is kind enough to record that, then my lord's officer, it would be, my lord, much easier for them that out of this 92 lakhs or whatever it is, my lord,
Yes, record an order.
my lord,
Or
after
after that, my lord, kindly see.
after
Okay,
the
just a
word,
minute. Learned advocates for the parties are present. This matter is put up for necessary clarification of the judgment and order dated November 26, 2025.
lordship.
In the said judgment and order, it is observed, এটা কোট করে দেবেন, ঠিক আছে, কোট। However, as submitted by the learned advocate for the insurance company, it is clarified that the appellant insurance company has already deposited
My lord, 92, 58,
92, 58,
750
750.
for the registrar general.
Okay, before this court,
My lord, out
stop.
lordship.
In terms of this order, after the disbursements are made to the claimants respondent number 1 to 4, in terms of this order,
Lordship.
the residuary amount shall be returned to the appellants upon compliance of all necessary formalities.
Grateful to your lordship.
I think this 40,000 will not cause any problem.
No. My lord, because that is a part of the original order.
Yes,
My lord,
yes.
that out of the total sum, first 40,000 would be taken.
Thereafter equal.
Thereafter, my lord, the balance.
So this will not cause any problem.
Yes, this will not.
Equally, my lord, respondent claimants, my lord.
ওইখানে also বলে দিয়েছে।
Payment to the balance awarded amount shall be distributed equally to all the respondents.
No.
My lord, respondents, claimants, my lord, because in respondents,
Respondents number 1 to 4.
My lord, respondent number 1.
extremely grateful to your lordship.
And it is further clarified that with regard to the disbursement amongst the respondents, it should be clarified as respondents number 1 to 4. Because all respondents means vehicle owner also.
Yes.
Respondents number 1 to 4.
Obliged to your lordship, my lord. Grateful to my lord.
Respondent claimants.
This paper book is not here.
My appeal is also there, my lord.
Yeah, it's ready for hearing.
But on appeal is ready for him. So far as the appeal of the insurance company is concerned, which is appearing in the list.
That is item number 9.
Item 9.
Anyway, ready for hearing in the month of January prior to that Lok Adalat?
I'm filing the paper book, my lord.
Yes.
My appeal, which will FMAT MB4 of 24 is to be appeared along with the lord. This appeal.
Yes, record an order. Learned advocates for the parties are present. It is submitted by the learned advocate that this appeal is ready for hearing and the paper books have been filed. Stop. As this matter relates to motor accidents claim, the matter is referred to National Lok Adalat to be held in the month of December. Stop. It is further clarified that FMA, the other is
FMAT MB4
FMAT MB4
of 24.
4, only 4.
4 of 2024.
The other appeal, FMAT 4 of 2024.
File is there.
Yes, which is treated in the days list by the consent of the parties. We also sent to the Lok Adalat. Fix 12/1/2026 for report of the Lok Adalat.
My lord, I'm for the appeal, my lord. It is insurance company's appeal, my lord. I have deposited the entire amount, my lord. Mr. Anup Kumar Bagh is appearing for the claimants, my lord. If your lordship directs for filing of the paper book, my lord.
Yes, sir. Yes. Yes, where is that slip, deposit slip?
My lord, I have handed
You
over.
have handed over?
My lord.
দেখুন তো কোথায় আছে, এই যে এই যে হ্যাঁ, এটা তো বলে দিয়েছি। The date for listing this matter in paragraph 3, 1st December 2026 হয়ে গেছে, এটা 1st December 2025। ঠিক আছে, এটা কারেক্ট করলেই হয়ে যাবে, তাহলে কারেক্ট করলেই হয়ে যাবে। হ্যাঁ, তাহলে এটা হয়ে গেল কারেকশন। এই যে এটা কিসের আছে, এটা এই অর্ডারটা, ওইটা তো আচ্ছা, ইয়েটা কোথায় গেল এই ড্রাফট? ইয়েস, দ্যাট ওয়াজ অ্যান অর্ডার 7/7/2025
My lord.
where direction was issued upon you to deposit the entire awarded sum. Have you filed that document?
My lord, I had filed in the previous court, my lord. There will be an noting of the department also, my lord, with to that extent, my lord.
That is 8,61,738.
My lord.
Yes, record an order. Learned advocate for the appellant is present. As the appellant, insurance company has deposited the entire awarded sum in terms of order dated 7/7/2025, there shall be a stay of the judgment and order dated 1/3/2025, passed by the learned judge, bench 4, City Civil Court, Calcutta, in MSC case number 51 of 2018 till the disposal of this appeal. So opposite party, the respondents have entered appearance.
My lord, they have entered, my lord.
The vehicle owner?
My lord, the vehicle owner has not entered. He was not there, my lord. Before
Anyway, as the respondents have already entered appearance, the matter be listed on. So how soon can you file your paper books?
My lord, after vacation, my lord.
As the matter is to appear for hearing, the appellants are granted opportunity to file paper books on or before 9/1/2026.
My lord.
Let this matter appear on 9/1/2026.
Grateful, my lord. दे देंगे सर, दे दिए जरूर उसका। नहीं सर, बेइज्जती हो।
Milord 12, I'm for the respondent insurer, Milord.
Lord, I'm for the appellant. I laid by Mr. Uday Shankar Chattopadhyay, my lord. Here is my paper book. The matter is ready for hearing, my lord. I'm requesting you kindly fix a date for
So
hearing.
can one is disposed. Can one of 2016. Whose application is this? Can one?
Milord, my learned friends.
Now, what is this application for? Can one?
My lord, I need to take instruction regarding that.
Okay, record an order. Learned advocates for the parties are present. It is submitted by the learned advocates that the matter is ready for hearing. Paper books have been filed.
Yes, my lord, I have just submitted the paper.
The paper books filed today be kept with the record and copy be served. As this matter relates to insurance claim, motor accident claims, and may be settled through the Lok Adalat, The matter is referred to the National Lok Adalat to be held in the month of December.
My lord, there is one submission.
Yes.
It has been previously sent to the Lok Adalat, but the matter was not settled between the party. My lord.
No, because parties did not agree.
Is not-
Yes,
Lordship will fix it up, not in the month of January, February, wherever my lord.
no,
wants.
if you can take instructions, I can send it.
Then I'll give another try, my lord. I'll give another try.
Mm.
So what shall I do? Shall I?
My lord, Lordship will fix it up for hearing because previously it had been to Lok Adalat, my lord, as my learned friend is stated.
Okay, let this matter appear for hearing in the month of January. So liberty to mention,
Lordship.
you mention it in the month of January.
Grateful, my lord.
Lord, 13 is my appeal. Two applications are on board today, my lord. One is my application for stay, the other being my application for condonation of delay.
So that condonation application is served upon the
I
respondent.
have served, my lord. That is what I was coming to. I have served, but it has come back as insufficient address. Though the address that I have put is the same as it is there in the cause title as also in the claim application. What my clerk told me that there was a court. Now I don't find a court here. But if there is a court, then I'll be able to
It is not
know
appearing
who
in the
the
list.
learned advocate is for the claimants. In the
No, no,
meanwhile,
do you-
my lord, the only
Do you know
difficulty
the
is
number so that you,
court,
if somebody has,
I need to go but down to
whether
the department
whether
again
any
and
whether
ascertain the number.
any person has entered appearance or not on behalf of the
There
respondent.
is a court, so definitely there is an advocate.
So you
for-
ascertain the name
Yes,
of the
I'll
advocate.
do that. In the meanwhile, my lord, what I am beseeching, my lord, is that this next date is fixed on the 5th. Now, my lord will kindly
Yes,
give me
record
an
an order.
interim production till that date.
Learned advocates for the appellant is present. None appears for the. It is submitted by the learned advocate for the appellant that the respondents claimants have already entered appearance.
My
Thus,
lord, kindly not record that because I'm not very sure of this. Possibly there is a court that I have need to go and check it.
learned advocate for the appellants, insurance company is present. It is submitted by the learned advocate for the appellant insurance company that the notice sent to the respondents claimants have returned with the remark
Insufficient
address. However, in the facts and circumstances, the learned advocate for the appellant is requested to ascertain as to whether anybody has entered on behalf has entered appearance on behalf of the respondents. Stop. Let this matter appear on 8/12/2025. As the matter is sub judice before this court, the parties may seek adjournment before the learned trial court, which may be considered.
I'm grateful.
I appear for the appellant, my lord.
The section 5 application I have received today itself, your lordship, at 11 o'clock. So, your lordship, I need to take instruction because there is a delay of about 3.5 years.
3.5
years.
3.5 years.
Lord, affidavit service may give.
Yes, record an order. Learned advocates for the parties are present. The application CAN 1 of 2024 is taken up for consideration. As the learned advocate for the respondents pray for time to seek instructions, the respondent is granted opportunity to file affidavit in opposition to the said application by 15/12/2025. Reply, if any, by 22/12/2025. Let this matter appear for under the same heading on 6/1/2026.
My lord, let it be 7th or 8th.
7/1/2026.
Deeply obliged. Affidavit service may be kept with the
The affidavit of service filed be kept with the record.
Deeply.
This appeal preferred by the insurance company on the question of my lord involvement of the
So can 3.
Can 3 is my application recording the attainment of majority in respect of respondent number 2.
Yes, let me see.
Kindly record the. I have my lord annexed the birth certificate and the Aadhaar card of respondent number 2.
That is
Report goes.
that means this respondent number 3 has attained majority.
Respondent number 2, Ripon Ghosh.
Okay.
Aadhaar card page annexure 9 and 8 is birth certificate. Kindly allow my application.
Okay, 37 2000. Yes, record an order. Learned advocates for the parties are present. The application can 1 of 2000, can 3 of 2025 is taken up for consideration. This application is directed for recording the majority of the respondent number 2. Stop. The petitioners in support of the application has filed the birth certificate of the respondent number 2.
Birth certificate and Aadhaar card.
Aadhaar card you have filed. So Aadhaar card of respondent number 2. Of respondent number 2. Upon perusing the petition and upon hearing the learned advocates, this application stands allowed. Let majority of respondent number 2 be recorded. The department to make necessary amendments in the cost title within 2 weeks.
Kindly fix the matter because paper book have been filed, paper book has been served.
Liberty to mention.
No, kindly fix the date on 6.
No, you mention. Let the amendments be carried out. Thereafter, you mention.
My lord, your lordship, kindly fix the matter on 16, 18. All in the meantime, department, my lord, we correct it.
You see,
Kindly-
16, 18, this bench will not sit. So
Not 16 December, January, in the month of January.
okay, let this matter appear on 12/1/2026. 12/1/2026.
I'm getting it.
Yeah.
For the petitioner, my lord, appellant. My lord. Affidavit of service. Attainment of majority, my lord, in respect of appellant number 2 and 3. Huh?
That is respondent number 2 and 3.
No, appellant number 2 and 3.
Appellant number 2 and 3.
Both the minors become major.
Yes, record an order. Learned advocates for the appellants is present. The application can 1 of 2025 is taken up for consideration. The appellants stroke applicants have in the said application prayed for recording the majority of respondent appellant number 2 and 3. The applicants in support of their application have filed the birth certificate and the Aadhaar card. Upon hearing the learned advocates and upon perusing the petition, this application stands allowed. Let necessary amendments be, let majority of respondent number 2 and 3 be recorded.
No, appellant.
Appellant number 2 and 3 be recorded. The department to carry out necessary amendments within a period of 2 weeks. Liberty to mention.
My lord, kindly fix the matter in the first week of January, my lord. After you
Let this matter appear on 13/1/2026.
Otherwise, my lord, they will not carry out in time. That is the problem. Okay. Rita আসেন, সুতুলা। My lord, I am appearing in this matter on behalf of the respondents claimants. My lord, I filed a separate appeal.
18 you are for the respondent
Yes, my lord.
and 19 you are for the appellant.
Yes, my lord.
So this application is for any application?
Yes, my substitution application, my lord. The injured, my lord, died during pendency of this appeal. So his legal years, my lord, impleaded. Mrs. Sucharita
Lord,
Paul
Mrs.
is
Paul
appearing.
she has not come today.
Okay, not today.
Not today. আজকে আসবেই না তাই না? তাহলে not today.
My lord, I appear on behalf of the appellant insurance company. This appeal is coming from first time for hearing. We have deposited. No, first time, my lord. Deposited the
Statutory amount.
Yes, I have deposited the statutory
I
amount.
have been instructed to appear on behalf of the claimants. So Lordship, I am appearing for the claimants.
So service upon the
not-
claimants, respondents may be dispensed with.
May be dispensed with.
Only
And
the vehicle owner has to be served.
Yes.
I don't know whether he.
No, he's appearing first time. No service is yes.
No
appearing.
service.
Learned advocate.
And Lordship, kindly
or-
only write me to serve a copy of the
Yes,
stay
that I will
application.
do.
No, he is the appellant.
Yes,
No, that is a copy of the stay application upon me.
Okay. Yes, serve a copy. Okay. Learned advocate for the appellant and learned advocate for respondent number.
Respondent 1 to 4.
1 to
1 to
4.
5. 1 to 5.
1 to 5 are present. The appellant insurance company has deposited the statutory amount of rupees 25,000. Thus, there shall be an ad interim order of stay of the judgment and award dated 16/7/2025 passed by the learned additional district judge Sodor Poschim Mednipur First Track Third Court in MSC case number 10 of 2020 for a period of 5 weeks. Stop. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest as directed by the learned trial court within the period of 5 weeks, excluding the statutory amount. Stop. In the event the awarded sum is deposited within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. As learned advocate has already appeared on behalf of respondent number 1, 2, 3, 4, and 5, service upon respondents number 1, 2, 3, 4, and 5 be dispensed with. The appellant shall take steps to cause service upon the other respondents. Okay, liberty to mention.
Deeply observed.
No, Lordship, still, Lordship, kindly give some date. It is January.
I'm giving you liberty to mention.
No, Lordship, already Lordship will grant a stay till disposal of the application.
Disposal of the, if they deposit the entire awarded sum, the stay order will continue till disposal of this application. Okay, so and liberty to mention.
So liberty to mention, then Lordship kindly direct the appellant or the me to prepare the paper book, otherwise for hearing. Sir, can you give that direction also?
Because service is not complete upon the other.
Paper book can be prepared. If they serve, if someone will appeal, who will serve? If I prepare.
Kindly direct the department to call for the local record. My lord.
Very well, Lordship. Call for
The
Lordship,
trial
record
court
with me.
records.
The inter certificate copy
The
with
trial
me.
court's records be called for.
Yes, Lordship.
And the appellant shall
At the
take
cost of
steps
the appellant.
to cause service upon respondent number 6.
Yes.
Respondent number 6 through the department.
Yes.
Deeply observed.
And liberty to mention.
Yes. 21, Lordship. I am for the
For the appellant, my senior is engaging another court.
Lordship, kindly.
Okay, not today.
Lordship, may I submit one thing, Lordship? So the
Yes.
judgment already been delivered. There is some correction is required. I have just
21.
no, the another the already judgment delivered.
Okay,
Some-
give a slip to be mentioned.
Yes, Lordship. Yes.
Inform the other side also.
Yes, that I will talk with.
Okay. 23, my lord, I'm appealing for the appellant. Yes. My lord, whose application is this? Can 2?
Can 2 is my application, order
What?
41. That is pending, my lord.
And
Order
can
14
three?
rule 27.
Can 3?
24 এটা? 23. 23. এই লিস্ট একবার দাও তো লিস্টটা। কি নাম্বারটা কত? দাদা 4275, man, that is scan number 2. That was the previous application for stay. And 3, that is old number 952. It was application under order 14 rule 27 for evidence.
And can 4?
4 is the new application for stay.
Okay. The
Previous application
No,
was
no.
disposed of.
This is already admitted.
Matter has already been admitted.
Anyway, the respondents have entered appearance.
My lord, respondent did not appear before this court. As per this honorable court's direction, matter has been advertised in the newspaper. Then also they have not appeared. But my lord, the copy has been served upon the learned advocate who is appearing before the learned court below in execution proceeding for the opposite party. Then also they did not appear. Now this matter has came up for my lord for stay of the execution proceeding.
Anyway, you take further steps. I'm extending the interim order.
If your lordship direct, I would, but my lord, they even paper publication they have not appeared. Even service to the learned advocate they have not appeared. My lord, then
Yes, take out an order.
and even department has
Learned
fixed
advocate for
the advertisement in front of their house. That is also in record, my lord.
Learned advocate for the respondents, appellant is present. It is submitted by the learned advocate for the appellant that in spite of due service, none have appeared on behalf of the respondents. Stop. It is further submitted that the copy of this application is also served upon learned advocate for the respondents decree holder who is appearing before the learned executing court. Stop. In the facts and circumstances, learned advocate for the appellant is requested to intimate by notice learned advocate for the respondents who is appearing before the executing court, intimating the next date fix. Let this matter appear on 12/1/2025.
My lord,
Pending hearing of this application, there shall be stay of the execution, title execution case number 10 of 2014, pending before learned civil judge senior division, first court Malda, for a period of 8 weeks from date.
My lord, may I permitted to mention, my lord? My lord, kindly go through the record of the department, my lord. There is a difficulty, my lord, on my part, my lord. I should have to made the court fees 4,630. At the time of filing the appeal, that has not been deposited. But I'm praying for liberty so that I can deposit that within. My lord, kindly fix a time.
No, where is
so
the
that
report of the stamp reporter regarding deficit court
it
fees?
should be on the record, my lord.
Let me see.
And my lord, another record, I go through the record, my lord. Another record, my lord, should have to return the, my lord, record to the learned court. Decree has not been drawn up. In appeal court, decree has not drawn up. In lower civil judge junior division, decree is wrong.
Okay. Decree.
My lord, previously it was sent to the learned court below. My lord, kindly go through the order.
Earlier it was no, you see, the appeal is admitted.
My lord.
And after condoning the delay.
My lord.
Now,
my lord, once
has not been filed within the
28/8/2023 of this court's order.
An appeal has not been filed with the memo of appeal. The copy of the certified copy of the decree.
My lord, certified copy of the decree has not been drawn up till date. And my lord, also there is a report that
Yes.
lower
court
court
fee.
record.
No, first of all, pay the court fees.
My lord,
Yeah.
kindly,
I'm granting you liberty. The appellant are granted liberty to pay the deficit court fees of rupees 4,530 on or before the next date fixed.
My lord, 4,630. My lord.
That is the fees. You have paid only 100.
Oh, sorry, my lord. I'm paying for apology.
530
My lord.
on or before the next date fixed.
My lord. And my lord, once kindly go through the order dated 28/8/2023. These courts send this record back to the learned court below for preparing the degree. Till that degree has not been prepared.
Anyway, another reminder has to be sent on the next day. In the meantime, you do the needful, pay the deficit
My
court
lord,
fees.
I should.
And intimate the other, the lower court advocate.
That is the.
4,000. It's a deficit court fees, so just a minute. Oh, 4,530.
Lord, I'm praying for apology, my lord. রিপোর্ট নেই দেখো আমি পরে ইয়ে পেয়েছি আমাকে নো অবজেকশন করে এসছে লিখে দিচ্ছি
Sorry, sir. No, ঠিক আছে, চলো।
Pass over.
No, time for the petition.
Okay, 24, yes.
Two applications.
Sir, I am appearing on behalf of only respondent number 4. There are several respondents in this matter.
Two applications.
Service is complete upon all the respondents.
Some of the respondent service is complete. This is affidavit of service.
So this CAN 3 is for substitution.
CAN 4 is for substitution.
CAN 3.
Main application has not been served.
Yes.
CAN 3 has not been served upon me.
Appeal
What is CAN 3? I do not know.
Until and unless
On the
substitution
previous
is made,
occasion,
the substitution application is.
What is that application? I don't know.
No, no. CAN 4 is substitution.
1, 2,
4 and 5.
So paragraph, you see, CAN 3, you have prayed for an order that the respondent number 2 died, living where and so as the legal heir.
Your Lordship kindly sees the order dated 26th of July 2023.
Hey, order sheet ta dekhi.
26th of July 23. CAN 3 is for the condonation of delay.
26th July.
26th July.
So serve one copy upon your learned friend. That CAN 3.
Already served.
Already served.
3 is not served. 3 has not served.
4 and 5 served.
You are representing whom?
Only respondent number 4.
3 is disposed of. Your Lordship kindly
Oh,
sees.
3 is disposed.
Yes, 26th of July.
কি ছিল ওটাই? কি ছিল সাহেব? আমিও পরে পেয়েছি। তোমার টাইম পারবি?
Okay, this is for respondent number 8.
Yes. 8 expired.
ওটা কন্ডিশন ডিলে ছিল।
এটা তিনটা condonation ছিল. 2 and 3 both are disposed of at the time of admission.
7/2023.
Correct. That's correct.
CAN 2, CAN 3 disposed of, তাই তো?
হ্যাঁ।
কি ছিল দেখে না অর্ডারটা অ্যাড করে।
এই তো। Both the application are allowed.
Oh, restoration application.
So that is disposed.
Yes.
So you are appearing for respondent number 4.
Four.
Okay.
My
And
lord.
respondent number 8 is sought to be substituted.
Substituted.
When did respondent number 8 die?
Not, on 7th of June 2021. Your Lordship kindly sees the paragraph 2 and 3.
In 2 and 3, paragraph 4, explanation of the delay.
Yes, yes.
Yeah, admit হয়েছে।
How many days delay? 1,437 days. That means about 4 years delay.
Yes. I don't have any information regarding death, and no intimation has been served upon by anybody.
Anyway, you are for respondent number 4.
4.
Yes, record an order. Learned advocate for the appellant and learned advocate for the respondent number 4 are present. The application for substitution being Can 1 of Can 4 of 2025 is taken up for consideration. The appellant in the said application has sought to delete the name of respondent number 8 on account of his death and substitute his legal heirs as specifically mentioned in paragraph 3 of the application. Although the application is filed at a belated stage by causing delay of 1,437 days, but the appellant has shown sufficient cause for not filing this application in time in paragraph 4 of the application. Stop. Thus, delay in filing this application is condoned. Amendment, if any, is set aside, and the name of the respondent number 8 is deleted from the cause title, and his heirs, as mentioned in paragraph 3 of this application, is substituted in his place and state. Let the department carry out the necessary amendments within a period of 2 weeks. Liberty to mention.
5. Respondent number 2 died. Can 5.
Yes.
31st of March 2019.
Ali Sahib.
Yes. When is the date of death? Have you which paragraph?
Paragraph 2, page 4.
Second line.
Yes, record an order. Learned advocate for the appellant and learned advocate for the respondent number 4 are present. This application, Can 5 of 2025, is directed for deleting the name of the respondent number 2 on account of his death and to substitute his legal heirs in his place and stead. Stop. Although this application is filed after at a belated stage and by causing delay of 2,234 days, but as the appellants have shown sufficient cause in paragraph 4 of the petition for not filing this application within time, the delay in filing this application is condoned. The abatement, if any, is set aside, and the name of the respondent number 2 is directed to be deleted from the cause title, and his legal heirs, as mentioned in paragraph 3 of the petition, be substituted in his place and stead. The department shall carry out the necessary amendments within a period of 2 weeks. Liberty to mention.
My lord, one thing, my lord, since my learned friend is appearing for the respondent number 4, his appearance may be dispensed with because
Okay, as
notice of-
respondent number 4 has appeared, service of notice upon respondent number 4 be dispensed with.
and my lord, paper book is almost prepared. Until
Other service of others, you have to cause substituted, you cause the service upon the
Yes, that is why
substituted parties.
after carrying out this department.
Yes, yes, that's why let the amendment be carried out, thereafter you mention.
Yes, Lord. Great.
Great. Everybody
বললেন না
না না এই নতুনগুলোকে
my lord, I beg to appear on behalf of the appellant, my lord. It's an application for the condonation of the delay, my lord.
Can one?
Can one, my lord. There is a delay only 21 days, my lord.
Yes, let me see.
I have explained this in the paragraph number 27, my lord.
You are representing all the respondents.
My contesting respondent, man.
No, which?
There are some pro forma respondents also.
Okay, the contesting respondents have been served and you are representing them.
My lord.
Yes.
The paragraph number 28, the solitary
27.
paragraph. Clear.
You are representing respondent number 1, 2, and 3. 1, 2, and 3.
My lord. 1, 2, 3, and 4, my lord.
1, 2, 3, and 4.
4, 2.
This 5 and 6, they are
opposite, pro forma opposite parties, as your lordship can.
Oh, they are the pro forma opposite parties.
My lord.
1, 2, 3, and 4. Yes, record and order. Learned advocates for the parties are present. The application Can 1 of 2022, which is filed for condonation of delay in preferring this appeal, is taken up for consideration. Heard learned advocates for the appellant and learned advocate for respondent number 1, 2, 3, and 4. Peruse the petition filed. Upon perusing the petition, it appears that the appellant has shown sufficient cause for delay in filing this appeal. Thus, delay of 21 days in preferring this appeal is condoned. The application Can 1 of 2022 stands disposed.
I'm grateful, your lords.
My lord, it's an innocuous application. Probably my learned senior friend will not oppose this.
Which Can 3?
Can 3. I tell your lordship, some facts are required, my lord. My lord would kindly take the post title of Can 3 once. My lord, Shamacharan Bishwas, my learned esteemed senior friend's client, was the plaintiff in a suit for specific performance. Initially, the suit was decreed. Suit was filed against Muhammad Mostaqin Molla.
Yes.
Now, Muhammad Mostaqin Molla preferred an appeal.
Yes.
The suit that was decreed, my lord, it was reversed. The appeal was there was a judgment against the judgment of reversal. They took out this appeal, the second appeal. The appeal got admitted. Now, post the judgment of reversal, my lord, Mostaqin Molla transferred the property to his daughter, Najima Khatun. Now, upon receipt of summons of this appeal, my lord, Mostaqin Molla.
No, you are the
applicant.
intervener. You are the you are intervening.
Yes, I am intervening. Basically, Muhammad Mostaqin. Now, I'll just indicate one thing. Now, Muhammad Mostaqin, he has gifted that property to Najima Khatun. Najima Khatun took out an application for substitution.
Who was the original respondent in this case?
Muhammad Mostaqin Molla.
Masiuddin Mullah?
Muhammad
Yes,
Mustaqim
Muhammad
Mullah.
Mustaqim Mullah.
Yes.
Was the original
Defendant.
defendant come respondent.
Defendant come respondent.
Yes.
And he is still the respondent.
Okay.
My lord, prior to the filing of the second appeal, Mustaqim Mullah had transferred that property to his daughter. So his daughter, what the daughter had done, daughter took out an application that is Can 2 of your lordship's brief.
And this is Can 3?
Yes, I tell you. Now what has happened, that application was pending. The daughter's application was pending. The daughter has died. Now the daughter...
Oh, before that substitution being allowed?
Yes, yes. Daughter has died. Now post the death of the daughter, Mustaqim Mullah, that is the father, he is already a party, and the other two brothers, 1 and 2. This is the application of the respondent number 1 and 2. Kindly takes in the matter of page 2. These two people, Masiuddin Mullah and Sofiuddin Mullah, have taken out this application for addition of party. The mother...
On the date of the original purchaser?
No.
No.
The daughter.
No, you see, original defendant was
Mustaqim Mullah.
Mustaqim Mullah.
Mustaqim Mullah is still alive.
Okay. He is still alive.
He is still alive.
He has sold the suit property.
No, he had not sold. He had gifted to his daughter.
Gifted to his daughter the part of the suit property.
No, the entire suit property.
Entire suit property, Muhammad Mustaqim Mullah had gifted.
Gifted.
To his daughter.
To his daughter.
So his daughter filed an application for substitution or addition as it may be.
Yes, yes.
So now the question is, during the pendency of that application, the daughter died.
Daughter died.
Dhoni died.
Dhoni died.
So that means these persons, these applicants are to be added in that particular application, Can 3.
No, as well as this appeal.
No. First of all, they have to add themselves in that particular application.
But how can they add? Because the person has died.
So in that application, they will be substituted.
That application we are seeking withdrawal. Because now what has happened, the right to sue has survived upon the father, that is the Mustaqim Mullah, the donor, and the two brothers. So Can 2 has become redundant now. We are withdrawing that. That can be disposed of.
Okay. Otherwise, there is an alternative. Add them as a party in that.
No, application, my lord. This appeal, let all of us add ourselves as party, my lord, the entire... And that application, my lord, will dismiss because that has become redundant. Can 2.
Yes. Yes, my lord, that can be done.
Yes, record and
What
order.
happened, my lord, after the appellate court passed the decree, lord, reversing the judgment, and during the period of appeal as provided, it has been transferred. Lord, your lordship can see the malafide on the
appeal is admitted or not yet
Yes,
admitted?
yes, yes.
Injunction was granted in that. Before that, they transferred it.
Prior to the order of injunction, prior to the admission.
Learned advocates for the applicant, intervener, and learned advocates for the appellant are present.
Yes.
This is an application for addition of parties taken out by the applicants number 1 and 2, namely Masiuddin Mullah and Sofiuddin Mullah, for addition of parties. Stop. It is the contention of the applicants that the suit property was alienated by the original defendant cum original respondent Muhammad Mustaqim Mullah in favor of their mother. What is her name? Which paragraph?
Mother, no, daughter.
In favor.
No, daughter.
Applicant's mother.
Yes, mother.
Applicant's mother.
Applicant's sister.
Okay. To the
Najima Khatun. Paragraph
the
3.
sister of the applicants, Nazima Khatun. Stop. As Nazima Khatun died during pendency of the earlier application for addition of party, being Can 2 of 2000. Earlier application was what? Can 2?
Yes, Can 2.
Can 2 of 2025.
Yes.
The said application has become infructuous and stands disposed. Stop. Thus, this application is taken up for consideration Upon hearing the learned advocates and considering the facts of the case, this court is of the view that this application should be allowed. Thus, I allow the instant application for addition of parties. Let the name of the applicants Masiuddin Mullah and Sofiuddin Mullah be recorded in the cause title of this appeal as respondents. The department to carry out the necessary amendments within a period of 2 weeks. Liberty to mention.
My lord, only one thing, the respondents, my lord, respondent number 1, 2, 3. The respondent number 1 is the father, original. He's there, and the other two sons have been
Another word, as the substituted heir of the deceased, Nazima Khatun, is already on record being the original respondent.
Yes.
No further substitution is necessary.
My lord. And the notice of appeal,
only the names of the applicants, Masiuddin Mullah and Sofiuddin Mullah, be substituted.
Yes. And my lord, only one thing, my lord, the notice of appeal be dispensed with regard to the respondents, because the learned advocate on record is appearing for the Mustaqin Mullah as well as Masiuddin and Sofiuddin.
As the original respondent and the interveners are represented by advocates, the service of notice upon these parties are dispensed with.
My lord.
My lord, you know, one thing, my lord, paper book is ready. You have to only fix the matter for hearing.
Yes.
And my lord, another thing, the order of injunction which binds the, my lord, original respondent may be extended so far the added parties are concerned. Otherwise, my lord, they may transfer it during pendency.
My lord,
Yes,
that might be passed, and my
the
lord,
earlier order of injunction shall continue till further orders.
my lord, the lower
And
court,
it will bind the added parties also.
my lord, only one thing, my lord, we are also seriously trying to the appeal to be heard expeditiously as possible, my lord.
Let the amendments be carried out to mention.
But lower
thereafter.
court records be brought at our cost, my lord.
Okay, the trial court's records be called for at the cost of the appellants. The appellant shall deposit the special
Appellant, no, respondent.
at the cost of the respondents. The respondents shall deposit the special messenger costs.
Yes, ma'am. No, no, sir.
You are representing all original defendant as well as
this.
My lord. My lord.
My lord, 30, I am for the appellant in this case, my lord. In this case, written argument and everything was already filed. Today, the matter is fixed for final hearing, my lord. It's a railway untoward incident case. I am ready.
Yes.
I am a respondent on behalf of the railway.
You are for the railway authority.
Eastern Railway. Already, I have deposited the written notes on argument on behalf of the respondent.
And I am ready with the facts of the case.
টোটাল কটা ম্যাটার গেছে লোক আদালতে মোটামুটি হিসেব করে আমাকে বিকেলের দিকে আপনার কাছে ট্র্যাক আছে তো ম্যাটার সেল ডিপার্টমেন্ট পাঠিয়ে দিচ্ছে তো ফাইলগুলো হ্যাঁ আচ্ছা আচ্ছা টোটাল কটা হচ্ছে 25-30টা
Yes, my lord. Kindly come to my lord, page number 4 of the paper book.
Page number 4, yes.
And that is the fact of the case. Fact of the case is that on 11/9/2019, deceased Pujan Chetri was traveling ex-Chennai to New Jalpaiguri superfast train, and he was traveling on 11/9/2019. And during the course of working at
Chennai
railway,
to New Jalpaiguri.
Chennai to New Jalpaiguri.
Via which area? Oh,
Ticket is filed, my lord. He was traveling from Chennai to New Jalpaiguri.
because this is Southeastern Rail and this is Northeastern.
He was traveling from southern to eastern side, to NJP side, and he fall down in the eastern railway side. He fell down near Varia, that is in eastern railway. He was traveling from Chennai to NJP. NJP is on a NF railway, and he fell down in Varia. That is on 12/9/2019. Whole day he traveled from 11/9/2019, and during the course of working at railway on 12/9/2019, he fell down from the train near Varia, and he died on the spot. Police case was registered under HON'BLE GRPS, UD case number 50/19 dated 12/9/2019. That is my lord, the facts of the case. Now regarding the documents, kindly come to page number, my lord. Page number 19. That is the final police report, my lord.
You have a type copy?
Type copy, my lord.
No. Where is the type copy?
Oh.
This is a handwritten.
This is a handwritten, my lord.
May I put an question there? That
You read out.
Yeah.
I shall see the type copy on the next day.
My
Yes.
lord, page number 19 is the final report, second page of the final report, my lord.
My lord, I am for the respondent in this matter, my lord. My junior is in court, my lord.
Yes.
Due to fever, my lord, I am unable to attend court, my lord.
Okay. Item number 20. Page 20.
Page 20. Page 19, final report, second page, my lord. Fourth line. With the help of Dome, we found that one railway ticket from...
It is marked with green color.
Yes, my lord. With the help of Dome, we found one railway ticket from Chennai Central to New Jalpaiguri, ticket number 04473008. Journey dated 11/9/2019, and one journey ticket number 79890. Journey ticket was prepared.
Which paragraph are you reading? Page
You know,
19 of the paper book.
Page 19 of the paper book, my lord.
No, how many lines?
Second page of the final report, fourth
This
line.
Yes, fourth line.
Yes, Your Honor, which I have highlighted, that one railway ticket from Chennai to New Jalpaiguri, white ticket number 0447.
Okay, one
3008.
railway
In
ticket.
which train? Which train?
Let me see. Train is unknown.
Railway ticket from Chennai to
New Jalpaiguri.
Yes.
White ticket number 0447 3008. Dated 11/9/2019.
Yes.
And which was properly seized, duly seized by the, and in the next page, it is mentioned during inquiry, it could be learned that he fell down from any running train. Just below that, it is mentioned that during inquiry, it could be learned that he fell down from any running train.
Yes.
That is in the final report.
Yes.
My lord, then page number 21 is the inquest report. That is not legible. So I have filed the English translation copy of the inquest report. That is in page number 39.
Page 39.
My lord, that is the English translation copy of the investigation report.
Page 39.
Page 39 of the paper book, my lord.
No, 39 is this site map.
Yes, my lord.
My lord, page number 45. My mistake. Page number 45, my lord. Page number 45, my lord.
Yes.
How the death occurred? I, according to the instruction of my senior ASI Arun Kumar Ghosh, along with C1651 Nazrul Islam and Dome person, was present at the place of incident. By looking at the situation and as per the statement of the witness, I came to learn that this person fell down from any unknown train and was grievously injured. His head and blood was coming out from nose and mouth, and he died on the spot. That is the conclusion of the inquest report, in which how the death occurred. And point number 13 of the inquest report, that is the opinion of the police officer as to the behind the death of the disease. Point number 13.
Yes.
According to the statement of the witness, I also have the same opinion that diseased person fell down from any down train and his head was badly injured and he died on the spot. That is the opinion of the police officer, my lord.
Yes.
Now, page number 23 is the station master memo.
Page 23. Yes.
As per reported by driver of E340020 that in came post number 175 by 21 and 175 by 23 between Vadia and up inside body was lying inside the track as recorded age 32 years male person. This is to take necessary action and do the needful. This is the station master memo which has been given by the railway. My lord, then page number 23 is the post-mortem report. Page number 23, 24, my lord.
Yes.
Post-mortem report, it is mentioned injuries are antemortem and accidental in nature. Last line, my lord.
Yes.
Injuries are antemortem and accidental in nature. And injuries are abrasion and fracture of leg and hand. These are the injuries which are spotted in the postmortem as well as the inquest report. In inquest report, it is clearly visible, my lord, that the injuries were deceased person head was badly injured, forehead was badly injured, elbow was broken, and leg was also badly injured. These are the injuries in the postmortem report, my lord. Now, page number 25 is the seizure list, my lord. The ticket was seized. It is mentioned railway ticket number 044730008 from Chennai city to New Jalpaiguri.
Yes.
This is a seizure list.
Reserve ticket.
Reserve
ticket.
Second class ticket. Yeah. Reserve ticket.
Plain ticket or reserve
plain
ticket?
ticket. Not all plain ticket. Plain ticket. This ticket has been verified. I will come to that, my lord. It's a normal unreserved second class ordinary ticket, my lord.
Second class ordinary
ticket, my lord. Now, my lord, page number 27, 27 is a ticket, copy of the ticket, my lord, which has been filed.
Yes.
044730008 MGR Chennai Central to New Jalpaiguri. This is the ticket, my lord. Now, page number 30 of the paper book, my lord. This is a case diary which has been prepared, my lord. Page number 30.
Page 30, yes.
Page 30, seventh line.
Seventh line.
Took photography of the dead body, as well took photo of the place of occurrence, and seen the dead body very carefully with the help of dome and found one railway ticket from Chennai Central to New Jalpaiguri, white ticket number 044730008. So in this case diary also, this ticket number is mentioned that with the help of dome, the body was searched and this ticket number 044730008 was found from the body.
The date tallied.
Date tally, my lord.
Date of the
incident tally, you know. Now, you know, page number 31. Third line. During an inquiry, it could be learned that he fell down from any running train compartment and was grievously injured and died on the spot. This is the case diary which tells about the bona fide as well as the fall, my lord. Now, you know, the most important thing is the railway has filed a report, and that is in page number 58, my lord.
Yes.
Page number 58, point number 5, my lord.
Yes.
Inquiry by RPF, point number 5.
Yes.
During inquiry, the railway ticket which was found from the position of the disease, as mentioned in the seizure list, was verified from DYCCM Southern Railway, Chennai, and learned that the said ticket was issued from booking office, Chennai. So they have verified the ticket also from the department. It was found out that the ticket was verified from Chennai. This is the one of the most important thing, my lord. And they have also verified the ticket. That is, you know, my lord, page number. Page number 87 of the paper book, my lord.
Yes.
Page number 87 is the verification of the ticket that has been verified, that it covers a distance of 2,256 kilometer, second class ticket, adult one.
Oh, it was a break journey.
No, it was not a break journey, my lord. It was directly from Chennai to New Jalpaiguri train.
Chennai to New
Chennai to
Jalpaiguri.
New
So
Jalpaiguri.
alienation is what? So this was a plain simple ticket from Chennai to New
Simple
Jalpaiguri.
ticket from Chennai to
So
New
not a break
Jalpaiguri.
journey.
Not a break journey, my lord. It's covers a distance of 2,256 kilometer. So he was traveling the whole day. He was traveling on 11 and he fall down on next day. So he has traveled on the train on whole day, and due to some reason, my lord, he has fallen down from the train. That is the thing. And Your Honor, regarding this, I would like to submit. Regarding this, I would like to submit the latest Supreme Court judgment, my lord, that is of Rajni, that is of 8 October 2025. হ্যাঁ দিচ্ছি আপনাকে পড়ে দিয়ে দিচ্ছি না পেজ নাম্বার 6 my lord.
Yes.
Page number 6, point number 13, 6th line. Mere technical irregularities or lapses in procedure should not defeat a legitimate claim under a welfare statute like the Railway Act 1989, particularly Chapter 13, which deals with liability of railway administration for death and injury to passenger due to accident. A hyper-technical approach which would frustrate the object of providing relief to victims of railway accidents should be eschewed. The instance on a formal seizure memo would amount to importing standard of proof which normally is sought for a criminal trial. Hence, we reaffirm that proceeding under Section 124A of the Railways Act are not criminal trial demanding proof beyond reasonable doubt, but welfare statutes are governed by the principles of preponderance and probabilities. Once the foundation facts of possession or issuance of a valid ticket and occurrence of an accidental fall from the train are established through credible material, the statutory presumption of bona fide travel must operate in favor of the claimant. The railway, as an instrumentality of the state, cannot defeat such claims by pointing the procedural imperfection in investigation or non-examination of formal witnesses. To hold otherwise would erode the beneficial character of the legislation and convert a social justice remedy into a forensic obstacle race. It is therefore declared that when an official railway inquiry or evidentiary record verifies the issuance of the ticket, that is in my case, corresponding to the date and route of the untoward incident, such verification shall constitute prima facie proof of bona fide travel, shifting the evidentiary burden on the railway administration. The absence of a seizure memo or the inability of the police to preserve physical evidence cannot be itself defeat a legitimate claim when the totality of circumstances supports the claimant version. This principle shall guide all future tribunals and High Court in construction Section 124A so that the statutory right to compensation remains real, accessible, and consonant with the humanitarian purpose of the enactment. This is the judgment of Rajni of 8 October 2025, my lord. And now, my lord, I am pressing one Supreme Court's judgment of Reena Devi regarding the interest point, my lord. Page 1, column D. The first page, my lord.
Yes.
Column D, Railway Act 1989, Section 124, claim for compensation. Interest. In absence of any specific statutory provision, interest can be awarded from the date of accident itself when liability of railway arises up to the date of payment, without any difference in stages. Legal position in this regard is at par with cases of accident claim under Motor Vehicles Act 1988.
Yes.
And my lord, I am pressing one more judgment, that is of Karnataka High Court of 21st April 2025, Yelema versus Union of India. This is regarding Your Honor, bona fide. So, my lord, according to me, my lord, there are two issues in this case. One is bona fide and fall. First issue, bona fide is admitted because the ticket has been verified and it came to be verified, Your Honor, from Chennai station. And second thing, fall also in my all the report, final police report, inquest everywhere. In case that it is mentioned that the person has fallen down from the train, Your Honor, my lord. This is my case, my lord.
Yes.
My lord, may I submit?
Yes.
My lord, kindly turn to page 95. Judgment passed by the tribunal.
Page 60?
95.
Page 95.
95, my lord. Before that, my lord, kindly come to page 58. My learned friend, kindly come to 58, my lord. Calculation. Last portion, my lord.
Yes.
On the basis of the documentary and circumstantial evidences, it is clear that the actual cause of death of the deceased is knocked down by any running train. Similarly, no railway ticket was found from the possession of the deceased. The incident does not fall under the definition of untoward incident because neither the deceased person was a passenger nor he fallen down from any passenger carrying train. Hence, no claim should be entertained by the railway for the death of the deceased. Inquiry report filed by DRM report, my lord, senior DSC. Then, my lord, kindly come to page 95, judgment passed by the learned tribunal, my lord.
This DRM report is filed after taking into consideration the police report.
My lord, my lord, my
Was
lord.
considered. Yes, then.
My lord. Then, my lord, kindly come to page 95, my lord, judgment passed by the learned tribunal. This application has been filed under section 16 of the Railways Claim Tribunal Act 1987, read with 124A of the Railways Act 1989 by the applicant, father of the deceased. Pujan compensation on account of death of the victim was a list such and such. My lord, Railway Authority filed his written statement, my lord. Kindly come to page 96. Stop, my lord. The respondent also submitted that the alleged photocopy of the railway ticket attached by the applicant in the claim application is disputed and not a valid railway ticket. And the time of the alleged incident is mismatched with the said ticket. The respondent disputed the allegation seizure list. The applicant did not mention any specific train number in the claim application involving the alleged untoward incident. The applicant was no personal knowledge on the issue, and all the statements made by the applicant are on the basis of hearsay. There was no record of alarm chain pulling of any train on the said alleged spot by any passenger of any train. There was also no report of falling down of any person from any running train in the register of guard or driver of any train. The respondent specifically denied and disputed regarding the alleged incident. No such untoward incident of falling down from any train occurred at all on the alleged date at the alleged place of the incident. As per Mr. Klam, on duty loco pilot of such and such, was the informed of the incident in which he started on such and such during his duty in train number such and such attached with EC number X Bardwan to Andal, which his train was passing kilometers such and such. Uh, Noticed one unknown male passenger lying inside the train of UP line number 2. Then, my lord, kindly come to the next para. The respondent specifically pleaded that it is not a case of falling down from any running train as defined under section 123C subclause 2 of the Railways Act 1989. Thus, the railway has platform framed. Then, my lord, learned tribunal framed the issues. My lord, kindly come to next page, my lord, 97. My lord, first issue, whether the incident on account of which the victim is alleged to have died can be termed as an untoward incident as defined under section 123C2 of the Railways Act 99. My lord, kindly come to the findings of issue number 1 and 2 by the learned tribunal, my lord. On the same page, my lord, 97. Para 6. The applicant has filed list of documents among which the railway memo number such and such. Exhibit A5 reveals that SM Durgapur issued memo such and such with a copy of such and such Durgapur to effect that the report of the driver of train number, a male person is about 22 years lying inside UP number 2 track at kilometer such and such as per the investigation report of the Durgapur GRPP under Andal GRPS under UD case number such and such. Based on the opinion of the inquest witnesses, the IO agreed that the disease fell down from any unknown train and having sustained serious injury, he died on the spot. Then, my lord, there was 3 inquest witnesses. Out of them, one was One was trackman of railway and another was RPF oblique Durgapur. The final report of GRPS brought out the fact that after receipt of the information, the IO, along with force, went to the alleged place of occurrence, found that a male dead body was lying inside the track of Waria. Found that a male dead body was lying inside the track at Waria. It dictated the outcome of the preliminary investigation. As per PM report, the death of the disease was caused by ant mortem accidental injury. Then, my lord, kindly 661, my lord, the applicant Kharga Bahadur Khetri, father of the disease, filed an affidavit affirming the fact contained in such and such. The disease was my son. I have then, my lord, kindly come to on the said paragraph 1, 2, 3, 4, 5, 6. I have no personal knowledge about the incident. I have no my lord, I have no personal knowledge about the incident. Then, my lord, kindly come to
He said that his son was coming from Chennai to this New Jalpaiguri in his main claim petition. He was returning from there. Did he state in the claim petition? Did this that was stated that he was returning from Chennai to Jalpaiguri? That he has stated. Yes.
That has stated.
my lord, I am coming. Then, my lord, kindly come to para 6.3. The respondent had mainly opposed that the dead body was lying inside the track. My lord, then, my lord, paragraph 7, the DRM inquiry report brought out the fact on such and such railway station issued memo number such and such that about such and such driver. No railway ticket was found from the possession of the deceased. My lord, page 99, my lord. Then, my lord, during inquiry, the IO of RPF recorded the statement of loco pilot EC where he stated the same thing, that when his train was passing brought through kilometer 175 such and such between Waria and DC OP, he noticed that one unknown male person was lying inside the track of UP line number such and such. He informed all concerned. Then, my lord, 7.2, my lord, they stated, third line, my lord, they stated that during search of the dead body, no traveling authority was recovered from the possession of the deceased. Only a bunch of keys was recovered. Sri D.K. Mishra also stated that the signature on the seizure list as Dhiraj Kumar Mishra was not done by him. No seizure list was prepared in his persons, my lord. Then, my lord, 7.3, my lord, third line, no railway ticket was found from the possession of the deceased. The incident did not fall under the definition of untoward incident
was
because
produced before the tribunal. Was railway
my
ticket
lord,
exhibited
my
before
lord,
the tribunal?
Yes, ma'am. It was
my
exhibited.
lord, my lord, my lord, the incident did not fall under the definition of untoward incident because the person was neither passenger of any train nor did he fall down from any train. Para 4, my lord, 7.4, my lord, upon summons Dhiraj Kumar Mishra, the Durgapur was present at such and such. Then, my lord, kindly come to the Dhiraj Kumar Mishra CW1 stated in court, my lord. My lord, kindly come to page 100, my lord. 1, 2, 3, 4, 5, 6. Sixth line, my lord. I found only one bunch of keys was recovered from the victim, my lord. I told by name and designation of Mr. Anup Kumar Ghosh. I did not sign on any document at that place of occurrence. After completion of inquiry examination, I returned to my post and noted down the incident. The RPF diary. RPF authority took my statement over this incident. This is my signature of my statement given before the RPF authority. My lord, GPR such and this is my signature of such and such. Then, my lord, kindly, this is not my signature on seizure list. My lord, kindly see. This is not my signature on seizure list. Seizure list was shown to the witnesses. The inquest report is written in Bengali language. I do not know what is the written in the inquest report. GRPS authority only told me that in this they wrote regarding the place of occurrence and for the purpose of removal of the dead body of the victim, my signature is required. Then, my lord, kindly, I did not know the contents of the inquest report. In the seizure list, my name has been written under serial number 3, but there is not my signature. Seizure list was shown to the witnesses. No railway journey ticket was seized by the GRPS authority in my presence, and that is why I did not mention the same in such and such. This is my short such and such. Then my lord kindly again my lord 101 my lord page. I cannot read Bengali language. Then my lord kindly come to the witness Arup Kumar Ghosh, my lord CW2 my lord. The incident probably occurred on such and such. The incident was such and such. I went to the place of occurrence with one constable to conduct the investigation over this incident. I have prepared the inquest report. On the inquest report, I took the signature of three persons. First signatory was one of relatives of the victim. Second signature was not known to me. Last signature was one RPF personnel. The incident occurred on 12/9/2019. I got information regarding the incident from Deputy SM. I come to know that one person fell down from the train and died such as such. My lord. Then my lord kindly come to page 102, my lord. 1, 2, 3, 5 line, my lord. One Mr. Dhiraj Kumar Mishra, one of the signatories, told before this court that the signature of Dhiraj Kumar Mishra on the seizure list is not his signature. He also said that no railway journey ticket was recovered from the possession of the victim. What is your opinion regarding his version? Answer: I have nothing to say. Then, my lord, kindly come to next para, my lord. Third line: I cannot remember the name of that type right now. According to the observation, I have written the victim fell down from the train. I noted down the name of the signatory of the investigation report. Someone told me that the victim was hit by a post. Someone told me that the victim was hit by a post and fall down from the train, but I did not write his name in his investigation report. I have written that the victim fell down from the train based on the opinion of the signature of the investigation report. I took their statement, but I did not write that they saw the incident such and such. Then, my lord, kindly come to para 8, my lord, Roman 1, my lord. The investigation report is prepared based on the investigation witnesses. Three inquest witnesses, my lord. Then, my lord, 103, my lord, page 103, my lord. Witnesses number 3 was summoned to the court for his evidence. He was present in court and he was examined and cross-examined as CW1, where the categorically stated that the dead body was lying inside the train's railway track. He did not know about the contents of the inquest report as such and such, my lord. Then, my lord, kindly, my lord, come to page 104, my lord, Roman 4. The applicant has filed a second class superfast ticket number such and such, which were claimed to have belonged to the seized. As per the seizure list, there is only about the seizure of second class ticket from the possession of the disease, nothing about the seizure such and such. As per the evidence of CW, the IO of GRPS clearly stated that nothing was seized from the possession of the victim at the place of occurrence. In the evidence, when he was told that Sri Dhiraj Kumar Mishra, one of the witnesses, signatory, told before this court that the signature of Dhiraj Kumar Mishra on the seizure list is not signatory, and that Dhiraj Kumar Mishra said that no railway journey ticket was recovered from the possession of the disease. CW2 had nothing to say.
Now the question: once second
My
class
lord.
was seized, did it mention that the place of journey from Chennai to New Jalpaiguri? This
No,
ticket,
my lord.
no,
No, my
this,
lord.
this ticket did not mention from which place to which place journey. That is
My lord,
second class
my lord,
ticket.
kindly see page 69, my lord. Chennai City to New Jalpaiguri, my lord. ticket number, my lord, UMF 04473 008. My lord, annexed in the paper book, my lord.
Yes, 11/9/2019.
My lord. My lord, then, my lord, that Dhiraj Kumar Mishra clearly stated in the evidence that no journey ticket was recovered from the beside the IO such and such key. A bunch of keys were found from the possession of the deceased, my lord. Then, my lord, Then, my lord, issue has been given in favor of the, my lord, respondent. Hence, my lord, 105, my lord, 82, para 82, my lord. Hence, we hold that the applicant has failed to prove that the victim died as a result of a fall from the train and the victim was a bona fide passenger. Then, my lord, issue number 3, in view of the foregoing, the issue does not require successor. My lord, then order the case is dismissed with no order as to cost. This is the case, my lord.
My lord, I will like to give some reply, my lord. Now,
My
in this,
lord, please, my lord, kindly, my lord, page 103, my lord.
You have given your written notes of arguments also.
my lord, I have written.
Both
My
of you.
lord, my lord, my lord, my lord, my lord, filed, my lord. On last occasion, filed, my lord.
Yes, page 103.
My lord, I'm again repeated, my lord. Witness number 3 was summoned to the court for his evidence. My lord, I'm placing this. My lord,
Page
nothing more.
3.
My lord, yes, my lord, I'm already placed. My lord, the appellant failed to prove his case, my lord. Hence, this appeal is liable to be dismissed.
I would like to give some reply, my lord. In this case, railway has themselves verified the ticket, and it was found out that the ticket was issued from Chennai Central. This is
Where do you get that?
You know, it's a page that is a railway report, page number 58, my lord. Page number 58 of the paperwork, my lord.
Yes.
Point number 5. During an inquiry, the railway ticket which was found from the position of the disease, as mentioned in the seizure list, was verified from the DYCCM Southern Railway, Chennai, and learned that the said ticket was issued from booking office MAS, that is Chennai. So they themselves have verified the ticket, and it is verified that the ticket was issued from Chennai, Your Honor. This is first thing, Your Honor. The second thing, my lord, a person who is a resident of Chennai, who is a resident of Darjeeling, he was traveling from Chennai to New Jalpaiguri, and he fall down at Wadia, that is 2,000 kilometers away from his place of residence. So why he will knock down, why he will be crossing the line in Wadia, Your Honor? That is the second thing, my lord. When a person is traveling from Chennai to New Jalpaiguri, such a long distance, 2,256 kilometers, and if a person falls down at Wadia station, that is in West Bengal, then why he will cross the line or why he will be knocked down? That is the second contention, my lord. And the third thing is, Your Honor, in all the report it is there that the person has fallen down from the train. In inquest, final report, case diary, everywhere it is mentioned that the person has fallen down from the train. And if you look into the judgment of this Rajni, which I have quoted, my lord, it is clearly mentioned that it is therefore declared that when the official railway inquiry or evidentiary record verifies the issuance of ticket, that is verified in my case, corresponding to the date and route of an untoward incident. Such verification constitute prima facie proof of bona fide travel, shifting the evidentiary burden on the railway administration. The absence of seizure memo or the inability of the police to preserve physical evidence cannot be itself defeat a legitimate claim when the totality of circumstances support the claimant version. This principle shall guide all future tribunal and high court in construction section 124A so that the statutory right to compensation remains real, accessible, and consonant with the humanitarian purpose of the enactment. So this thing should be noted, man.
Yes, that's all.
That's it.
Yes, recorded. Learned. You have filed your written notes also.
I have filed my written notes.
Learned
My lord.
parties are present, are learned advocates. Hearing is concluded. CAB.
Much obliged.
Much obliged.
The Dorkar Newton.
My lord, kindly recorded, my lord, on last occasion, written notes of argument we filed, my lord.
Both of you have filed written notes.
Yes, ma'am.
On the last
Both of
occasion.
Yes.
আগে টিটি তো লেখা ছিল written notes of arguments is filed.
No, my lord, there is no order, my lord.
No, my lord, there was a previous order also.
Whether I have recorded written notes of arguments?
This was from other bench in Etadam.
No, my lord, my junior filed on last occasion, my lord. There is no order on that respect, my lord.
When written notes of arguments filed. Oh, but written notes of you have filed it on the last occasion or today?
No, I have filed on last occasion. The other side has filed mine.
Taken in record দুটো আছে just verify.
I have submitted in the bench of Anana and my learned friend has filed on last date.
Let it be verified.
Yes, ma'am. হ্যাঁ আমি করেছি এনেই করেছেন লাস্ট ডেট
No, appellant. You are for the
আই
appellant.
এম ফর দ্য অ্যাপেলেন্ট মাই
লাস্টে আমি একটা দিয়েছি তো দিয়েছি
হ্যাঁ উনি দিয়েছিলেন আমাকে কপিও সার্ভ করেছে
Yes, the written notes of the parties have already filed written notes of arguments which are on record.
My lord, much okay.
My lord, the matter is ready for the hearing, my lord. Kindly fix up in the month of January, my lord.
But I am for the respondent insurance company, my lord. My lord, there was direction to file written notes of argument, my lord. Let those come before the hearing of the matter, my lord.
Written notes of arguments have already been filed.
No, my lord.
No.
Some time, my lord.
Yes, record and order. Learned advocates for the parties are present. Let this matter, which is ready for, let this matter appear for hearing on 12/1/2026.
Much all right, my lord.
I'm grateful to your lord.
My appeal, Mr. Pahari has not come today.
Yes.
Not today only.
Okay, not today.
Last question, I have filed paper book. Lordship, this is injury case and Lordship enhancement of the award money. Lordship, the appellant was student, 13 years old, and he was, Lordship, made accident for which 90% injured. That has been exhibited. Lordship, here my appeal is, Lordship, 3 grounds mainly. Learned Tribunal Judge Lordship considered 15,000 per annum income. And second is, Lordship's no future prospect. And third one is, Lordship's
No, what is the nature of injury?
nature of injury.
Any disablement?
Disablement.
Yes.
Yes, disablement.
Page 28. Page 28, then Lordship 29.
28 and 29.
Amputation.
Okay.
Leg-
The disablement certificate issued by the medical board.
Yes, Lordship. Yes, Lordship.
28.
The doctor has deposed.
Left leg, Lordship, amputated knee. Through knee amputation, left and weakness right leg. 90%.
Nature of documents, yes. 90%.
Yes,
Okay.
Lordship. Column B, diagnosis in her case is through knee, amputation left, and weakness right leg. Page 29.
So how much you claim? 3,50,000. Issue
Said
number
Lordships.
issue number 6. Whether the claimant is entitled to get 3,50,000.
No, Lordships. In claim petition, I have stated 8 lakhs.
How much it is awarded?
Awarded Lordships 3 lakhs. 3 lakhs 2,000. No, Lordship. Then victim compensation is coming around. Yes, 3 lakh 2,500. 15,000 per annum notional income, and that is also Lordship 90%. And the 15 multiply, then comes to Lordship 2 lakhs 200 500 2,500 and 50,000 for pain and
That is
suffering
what?
and lump sum Lordships.
Okay, how much is it?
50,000.
Victim support is 120. He was 11 years.
Not as per law, Lordship. Lump sum amount has been given.
Challenge with the
Lordship, page 32. Judgment
yes,
portion,
yes.
page 3. Third paragraph, Lordship. This is the case, Lordship, 2011.
So yearly income is considered as 15,000.
15,000.
This person was a student.
Student, 13 years student.
Actually, no income at all.
No, maybe in case of students also there are different decisions.
Yes, Lordship. Yes, Lordship.
Yes. Student of which class in the as per depositions?
Class 2. That is also not. উনি মেয়ে ছেলের বয়স 11 বছরে আমার গান মারতে শিখতো নজরাতে পুকুরেতে ঘটনা দাঁড় করা হয়েছে rated.
Nothing regarding a.
Not
No, education.
অনিমেষ বিশ্বাস আমার নাবালক পুত্র
No, which paragraph? This.
No, which?
No, the judgment of the learned trial judge. There is an observation that he was a student.
Student, yes.
Amputation. This is admitted.
Yes.
This is admitted.
And permanent disability.
Permanent disability.
90% permanent disability are admitted. And it has been proved also. There I cannot say anything.
Which paragraph? This person was a student. This. Yes, evidence of PW1. Victim was a student.
Yes.
And his income should be considered 15,000 per annum.
15,000 per annum.
Should be
Oh,
less.
where is the deposition? No, claim it is 8 lakh.
Claim it.
Lordship knows there are several judgment passed in Honorable Supreme Court as well as Lordships, our High Court also Lordships, where Lordships 3,000 is considered national income and Lordships loss of immunities, general damages that has been attached as 5 lakhs and Honorable Justice Ananya Bandyopadhyay, very recent Lordships past judgment and their lordships in several heads that has been considered for a student.
Yes.
দিন তো দাদা এটা
ওটা নিন।
কপি আছে
কপি একটাই আছে আপনাকে দিয়ে দেবো এটা Lordship, page 4.
Yes.
Several columns. And it is a fact, Lordship, once injured, then the person is not able to, she is
90% disability, leg amputated.
Yes, Lordships. Then his Lordship's life expectancy also, Lordship, very short. The rest of the life, Lordships, at least.
Yes, what do you say?
Another judge,
you said that judgment is all correct, nothing to interfere. Already he has considered his income as 15,000 where he has no income at all.
Lordship, another judgment passed by the Honorable Justice Subhendu Samanto, there are 3,000 considered and 5 lakhs for general damages. And future prospect after ratio, Lordship, 40%. That should be considered. And here, learned tribunal judge consider Lordship lump sum 50,000. And that is not applicable as per law, Lordships. The Lordships prononciatory judgment, Lordships ratio, and Lordships Sarula Verma also, Lordships considered that future prospect on that ratio basis should be considered.
Yes, record an order. Learned advocates for the parties are present, are learned advocates. The appellant before this court was a claimant before the trial court under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 7 January 2023 passed by the learned additional district judge, Third Court, Barhampur, Murshidabad. Stop. The case of the appellant claimant before the learned trial court may be summed up thus. Next. Next paragraph. On 11/4/2011, at about 11 hours, one truck bearing registration number WGQ-1207 coming from Shagorpada towards Jolongi in rash and negligent manner and with excessive speed dashed Animesh Bishwas, then aged about 11 years, at Ghoshpara Bridge under PS Jolongi, Murshidabad. Stop. The victim sustained severe bleeding injuries. Stop. Local people shifted him to Shadi Kandiar, SADIKHANDIAR, PHC, wherefrom he was referred to Barhampur New General Hospital for treatment. Stop. Thereafter, the victim was admitted in Jivandeep Special Care and Diagnostic Center Private Limited at Barhampur for his treatment. Stop. The matter was reported to the police authority and a case was instituted. Stop. The victim has been disabled and lost his physical capacity, and he was a student at the time of accident. Stop. The opposite party, National Insurance Company Limited, the respondent, National Insurance Company Limited, contested the case by filing written statements. Stop. Issues were framed. Stop. Upon considering the evidence and upon hearing the learned advocates, the learned trial judge was pleased to dispose the claim case by observing and directing as follows. Acha, quote. Ekhan theke, huh? Hence it is ordered. Page 33, folded page. The appellant claimant, being aggrieved by the learned trial judge, has come up with the instant appeal. Stop. The ground on which the judgment of the learned trial court is assailed is that the learned trial court assessed the yearly income of the claimant appellant as rupees 15,000, which is not at all reasonable, and the appellant claimant was a student at the time of incident. It is further submitted by the learned advocate for the appellant that the compensation awarded is a very meager, considering the income which is taken into consideration and the general damage which is awarded. Learned advocate relies upon two decisions passed by a learned coordinate bench of this court. Number 1, FMA 83 of 2024, Jalema Bibi versus National Insurance Company Limited and others. Number 2, Sri Rajkumar Das versus United Insurance Company Limited and another. FMA 1291 of 2010. Learned advocates for the respondent, National Insurance Company Limited, submits that as the victim claimant was a student, the learned trial judge rightly assessed the notional income as rupees 15,000 per month. Stop. Upon hearing the learned advocates and considering the facts of the case, the judicial decisions relied upon and other decisions, judicial decisions relied upon, and considering the fact that the victim was a student of 11 years, the monthly income ought to have been considered at rupees 3,000 per month. In the event rupees 3,000 per month is considered, the yearly income comes to rupees 36,000. As the victim suffered disability of 90% Okay. 36th yearly income. The future prospect, 36th yearly income.
40%.
Disability, and considering the age, the future prospect should be at least 40%. Thus 40%, yes, how much it comes? 40% of 36,000?
I'm calculating the same. 36.
And it has to be 90%.
Lordship, kindly 100%. That should be 90%. And Lordship, whereas Lordship 80%, that is also Lordship.
Okay,
Both
40.
the, it should be Lordship 100%. This 36.
That is 14,400.
Lorships. $36,000. Yes, Lordships.
Thus, the 40% of future prospect should be added, and
Plus 14.
40%. 40% if added to the annual income, it comes to rupees 50,400. However, as the disablement is 90%, rupees 50,000 is taken up for consideration.
Lordships.
The victim at the time of accident was 11 years. Thus, the multiplier shall be 15.
15.
Yes. Thus, the
50.
compensation on account of disablement comes to rupees 7,50,000. In addition, the victim is entitled to get rupees 50,000 for pain and suffering. Thus, total compensation which the appellant claimant is entitled is rupees 8 lakh. Thus, this appeal,
Lordship, future medical treatment and
whatever it is, 8 lakh is reasonable.
Lordship, 5 lakhs should be considered for general damages. Lordship,
Anyway,
not
5 lakh?
50,000.
5 lakh
5
and
lakhs.
no.
7. Lordship,
see,
that is income.
50,000, and then you see 50,000 into 15, 7,50,000. Regarding pain sufferance, I have given 50,000, so it comes to 8 lakh.
Lordship, this is not at all reasonable. Lordship, 50,000 is never. Lordship, 5 lakhs should be considered. Each and every court, Lordship, Honorable Supreme Court, more than that, I am not there. But our High Court Lordships also 5 lakhs, 3 lakhs, 4 lakhs, but 50,000 not, Lordship.
Anyway, see, pain and suffering, it depends. Okay, 1 lakh.
Future medical
Okay, pain and suffering is 1 lakh.
and non-pecuniary
1 lakh.
damages, Lordship.
Thus,
several columns
rupees
Lordships.
8 lakh.
5 lakhs should be considered, Lordship.
I made it 1 lakh, okay.
Lordship, Lordship, several columns is Lordships there, and 5 lakh general damages.
Yes, what you
not
say?
pecuniary.
No, my lord, it is okay. 50 lakhs is 50,000. Okay.
Lordship, it is not, Lordships.
Okay.
Lordship, at least.
Okay, it comes to 8 lakh. Okay, I'm granting another 50,000. It comes to 8 lakh.
Lordship, my humble submission, Lordship.
In the facts and circumstances of the case,
50,000 should be.
the loss on accounts of pain and suffering is enhanced to rupees 1,50,000. Thus, rupees 9 lakh is the total compensation.
Future
Which the
expenses, loss of
I've taken a future prospect. I've taken a future prospect. Rupees 9 lakh is the total compensation which the appellant claimant is entitled from the respondent number 1 insurance company. Thus, the order passed by the learned trial judge stands modified to the extent the respondent number 1, National Insurance Company Limited, shall pay
Non-pecuniary damages, lordships.
rupees 9 lakh to the appellant.
My lord, they have already received the entire awarded amount.
Okay, just a
Yes,
minute. 9 lakh.
Person, it is
9 lakh.
living person. It is the entire life will be
9 lakh.
struggle, lordships. He is living
To the appellant within a period of 8 weeks from date, along with interest at the rate of 6% from per annum from the date of filing the claim case till the date of this order. Stop. In the event the compensation which was awarded by the learned trial court of rupees 3,02,500 is already paid.
already paid. Already paid, lord.
Already paid.
Satisfied.
The balance amount along with interest from the date of filing till the date of this order shall be paid to the claimant's appellants. So total is 9 lakh.
Lordships, that is not permissible, lordships.
Three
At
times
least-
you are getting.
Lordships, in this way, that cannot be explained, lordships.
Now you see.
Lordship, being a injured person, 90% disability.
Okay, very well. I have not taken 90%. I have taken full-fledged.
Lordship, but 3 lakhs, 350 lakhs, lordships, that is considered. Here, lordship, both.
Okay, now you see.
Both the judgment, lordship, consider 5 lakhs. So your lordship.
Very well. You see, if you can get it enhanced by the apex court, you go and see if it can be enhanced.
But lordship, they are in trouble in before your lordships. But we will consider that. But
if some
how they will.
amount can be enhanced, you will try.
Lordship, when?
Before rising, I please one for mentioning. Since one matter is fixed at 2 p.m.
There are 2 matters fixed, one appellate side, one original side.
The after 2 the
Okay, only fixed matters will be taken up. ওই যেটা দুটো ফিক্স আছে অ্যাপেলেট সাইড আর অরিজিনাল সাইড আর জাজমেন্টস অ্যাপেলেট তারপর অরিজিনাল সাইড
judgment of both first your lordship.
Yes, judgment thereafter another appellate side matter, thereafter original side matter.
for the inclusion of part matter, my lord. Upon
Inclusion-
notice.
Yes.
Upon notice. Much.
Yes, appeal is allowed. Thus, the appellant claimant is entitled to rupees 3,07,600 compensation from the respondent number 1. The respondent number 1 is thus directed to pay rupees 3,07,600 to the appellant within 5 weeks, along with interest from the date of filing of claim case till date of payment. In the event rupees 55,000 as directed by learned trial court is already paid, the balance amount with interest be paid.
And this payment be permitted to withdraw. Your lordship.
No, I've directed payment, not deposit. I've directed payment.
That the responding insurance company will deposit the amount and the claimant be permitted to withdraw.
Okay, so instead of payment, shall deposit.
And deposit before the office of the
Yes, to deposit in court.
deposit before the office of the learned registrar general.
Yes, yes, yes.
And claimant banner, only one claimant be permitted to withdraw. Claimants.
Yes, upon such deposits, claimants will be permitted to withdraw.
I'm getting.
I'm for the appellant insurance company, my lord.
Yes. Hence, the appeal FMA 868 of 2025, along with COT 149 of 2025, stands disposed. The judgment and award dated 21st February 2025, passed by the learned additional district judge, 4th Court, Purbo Bardhaman, in MSC 38 of 2015, stands modified to the extent that the claimants respondent number 1 and 2 are entitled to compensation of rupees 20 lakh along with interest at the rate of 6% per annum from the date of filing of the claim case till the date of this order from the appellant. The respondent number 1 and 2 are permitted to withdraw rupees 20 lakh along with interest at the rate of 6% per annum from the date of filing of claim case till the date of this order. The residuary amount lying in deposit be returned to the appellant insurance company upon compliance of the formalities.
My lord, one thing I should mention.
My lord, along with interest, my lord, the refunded amount will be
Whatever it is, after payment, this
the
come along with
balance amount will be refunded.
whatever is the balance that will be refunded.
My lord, with regard to judgment on
My lord, kindly,
your lordship, my lord,
kindly
desire
will not refund it to me, my lord.
company.
My lord.
No, I have
my lord.
directed.
My lord, your lordship desire directing the responding insurance company will deposit the amount within a particular period.
Yes,
Kindly-
5 weeks, I've stated.
Yes, yes.
My lord, item number 2, my lord.
Yes.
My lord, the balance amount will be refunded to the appellant insurance company along with interest.
Whatever is will be lying, that will be refunded.
My lord, with interest, if it is not mentioned, department will not give,
Order
my
is
lord.
clear, okay.
My lord, I'm grateful, my lord.
Yes, I am taking one appellate side matter, thereafter fixed matter, thereafter I am coming to this original site.
26 অর্ডার আছে 26/11 অর্ডার হয়েছে নামানি তো ফাইল তাকে দিয়ে দেবো না টোল আমার দিয়ে সব দিয়ে দেবো
My lord, I am for the
এই আছে
appellant's defendant, my lord.
দিয়ে দেবো টোল দাম সব দিয়ে দেবো সকাল করে ফার্স্ট অর্ডার দিয়ে দেবো
You are the appellant defendant.
Appellant defendant.
Yes.
My lord, the scope of the suit is very much limited, my lord. The plaintiff of the suit being my sister, married sister.
Who is for the respondents? You are, yes.
Plaintiff of the suit is my married sister.
Yes.
She filed a suit for partition in the year 2011.
Yes.
In that suit, preliminary degree was passed. After preliminary degree, the final degree proceeding was going on. During course of final degree proceeding, a compromise was discussed and ultimately held.
Final degree was passed.
Final degree on compromise passed. The present defendant respondent, who was the plaintiff in the earlier suit, he signed in the agreement of compromise, his lawyer signed, and the allotment was prepared by the map being made, and on examination of the parties, and the compromise was effected. Well, after compromise is effected, in the next year, the present plaintiff again filed another suit, this suit, stating that the map which has been agreed to be annexed with the compromise petition, that has not been annexed. Another map has been annexed, and on basis of that, another suit was filed for modification of the degree or cancellation of the degree. The trial court dismissed the suit. Thereafter, my sister preferred appeal. Appeal court allowed and suit degreed, and against that we preferred appeal. My lord, in the appeal court, my lord, the matter came up for admission. My lord, ground has been, my lord, set out, my lord, points of my lord decision or point of determination has been, my lord, formulated. My lord, kindly see, one point is very whether in view of the compromise being made and effected, whether suit is at all maintainable. Very pertinent question, and it is in fact, my lord, decided on several proceedings, my lord, several pronouncement is also there, my lord. So let us, my lord, see the plaintiff's case. My lord, have you?
Yes.
Paper ইয়েটা দিন না, lower court record দিন.
No, this is page 1. You see, second appeal scope is very limited. Okay? So limited points of law you have to argue.
Yes.
So So no question of going through the evidence and everything.
No, not necessary, not necessary.
Yes.
But my lord, here, my lord, I want to, my lord, highlight certain points, my lord. The present plaintiff filed earlier suit. After protracted litigation, my lord, naturally, when the suit has been filed, the relationship will become tense. After protracted litigation, suit filed in the year 2011, and preliminary degree passed in 2015, and in 2016, compromise has been held. The agreement of compromise was signed by the plaintiff, also signed by the plaintiff's learned advocate. The draft was prepared, and draft or sketch was also prepared by the surveyor. In the second suit, neither plaintiff examined his lawyer who conducted the earlier suit. Earlier suit, the lawyer also signed in the compromise. He has not been brought in evidence. The person who has prepared the sketch, that person has also not been brought in evidence. Another person, according to him, he is the expert. That person adduced evidence, and on basis of that evidence, the compromise has been set aside.
By the appeal court?
By the appeal court, not by the trial court, because by the trial court particularly, first of all, suit is not maintainable, because only remedy is under order 23 rule 3A is to approach the court which passed the degree. What is the logic behind? Logic behind is, my lord, the court viewed the entire thing, because that court is the competent court who has the best knowledge about how the things conducted. That's why law has been formulated that whatever you are to say, you are to go to that particular court and agitate your grievance in that particular proceeding, because it will be, if separate suit is permitted, that will be at the one hand, my lord, to avoid the court who experienced or viewed the total affair, one thing, and second thing, it will be, object will be to open the Pandora's box, again suit, again appeal, again second appeal. That is not the intention of the legislature. What is the intention of the legislature? It is to the party, aggrieved party, is to approach the party.
That is approach by way of simpliciter application or by suit?
By application. By application, because that court in that proceeding or in that suit, he is to approach that compromise. First of all, it is the duty of the judge before entering, before passing degree of compromise, to see whether the
it is lawful
or not, and whether the party voluntarily agreed to come into compromise or not. It is the duty of that court to verify the same. And in the present case, not only the plaintiff herself or she was not fighting in a person, but through the assistance of a lawyer. So it is the duty of the lawyer also to ascertain, verify, and and to judge whether the compromise is effected in terms of the agreement between the parties or not. And judge will, it is the duty of the judge to ask the party whether he has signed it, who has agreed it, and whether it is in lawful or not.
Yes.
So, my lord, without going the same, my lord, he has filed a separate suit whether that is sustainable or
Order
maintainable.
23, whether it is maintainable.
Yes, whether, my lord, my lord, I shall file the recent judgment, Supreme Court judgment, my lord, that will clear the matter, my lord.
Yes, order 23, whether it is
Yes,
maintainable or not.
yes, my lord, my lord, I am filing a judgment, my lord. This is the facts of the case. He has, my lord, my lord, kindly, that's why I am trying to bring the evidence, my lord, that the plaintiff, that means the present respondent, came into box. She candidly agreed, my lord, candidly, my lord, admitted that yes, she signed in the agreement of compromise, and her lawyer also signed. This is also an aspersion of the upon the court also, my lord. This is not at all permissible under the law. At one chance, the matter was admitted.
Yes. So the question of maintainability of the suit comes into
Yes,
existence.
my lord, kindly one judgment I am showing your lordship. It will become crystal clear. Very recent judgment. একটা কপি দাও তুমি, এইটা দাও, যেটা আমি দিয়েছিলাম। Similar case, my lord, similar. 2025, volume 3, ICC Supreme Court, page 636. This judgment has been decided on 21st of April 2025. Very recent judgment. My lord, kindly see. I am first of reading head note, then I go to it. But compromise degree. My lord, kindly see. Compromise degree.
Yes.
Challenge as to.
Page, paragraph.
First, my lord, head note I am putting, then I go to.
Yes.
My lord, Civil Procedure Code 1908, Order 23, Rule 3A. Compromise degree. Challenge as to. Before passing a degree on the basis of a compromise, court has to satisfy itself that the suit has been adjusted by a lawful compromise. Once court passes a compromise degree, after such satisfaction, degree cannot be challenged in appeal, as no appeal lies against a compromise degree. Next, compromise degree. Challenge as to. Compromise degree cannot be challenged by filing a fresh suit. Whatever, my lord, this is the present case. Compromise degree cannot be challenged by filing a fresh suit, as there is a bar on filing a fresh suit challenging the consent degree on ground of legality of compromise under Order 23 Rule 3A. Only remedy against the compromise degree is to file a recall application. My lord, kindly see, whatever was your lordship was considering, that is the intention of the legislator. My lord, on the ground of legality
this is
compromise
introduced by amendment in 3A.
Yes. Only remedy against the compromise degree is to file a recall application before the court that had passed the degree. Then, Civil Procedure Code Order 2, Rule 2 and Section 211, bar under Order 2, Rule 2, res judicata suit for declaration that compromise degree is null and void, and for partition. I mean, our case is partition. Suit also barred under Order 2, Rule 2, as it did not include all properties which were part of the suit. Suit also hit by principle of res judicata or by constructive res judicata. This is also vital. Again and again, one thing will be decided by the court. Court has no business, as plaintiffs cannot re-agitate their claim regarding partition of the suit property.
So apart from maintainability, have you challenged it on merits?
Yes.
This maintainability point is there.
There, I have also challenged merit because
he is the ground which is formulated.
Yes, I have challenged it on in the written statement. I have dealt with it.
So question is, this appeal is to be heard out on the ground which is formulated.
Yes,
that is the maintainability point. So,
my lord, kindly see, my lord, this is a very formal matter, my lord. The present, the present appeal very elaborately dealt with, very elaborately. The present appeal arises out of a pure civil proceeding initiated at the hands of the present appellant in the year 2003. The appellants filed a suit for declaring a compromise degree cannot enter into between the respondent defendant as null and void and not binding on the appellant. Additionally, the appellant also sought partition of a certain share in the ancestral property which was in the possession of the defendant. The trial court dismissed the suit of the appellant by order. Thereafter, the appellant filed the first appeal before the High Court, which was also been dismissed by the impugned order dated. Since the present matter concerns various suits, we would like to state the facts of the matter in short, and the same are as follows. In 1974, a family partition takes place between the brothers and their father, that is appellant, that is father, his 5 brothers, and the appellant's grandfather, and the family property was partitioned, which was registered. Thereafter, in the year 1998, the appellant filed a suit against their father and mother, seeking partition and division of ancestral property by metes and bounds. However, during pendency of the suit, the grandfather of the appellant filed a different suit for partition in which the 6 sons, including appellant father, were a party. In that it was stated that a part of the joint family was mistakenly left out in the left out of the 1974 partition. By the order dated, the trial court passed a degree based on a compromise between the defendant, under which the 7 acres of the land was equally divided amongst the appellant's father, his 5 brothers, and appellant's grandfather. Consequently, 1 acre out of the 7 acre fell to the share of the appellant father. Taking into consideration the compromise degree dated 18/1/2000, the trial court, by order dated, decreed the appellant's partition suit, and the appellants together received half of the share of their father's party. Consequently, both the cases were decided. That the 1990 suit was decided on 18/1/2000 by a degree of compromise, and later the 1998 suit was decided on based on the degree of compromise passed in 1999 suit. From here, the main dispute arises. In 2003, the appellant filed the present suit, seeking a declaration that the compromise degree dated 18/1/2000 is null and void, as according to the appellant, that 7 acres of land was their father's property and not the ancestral property. Thus, the appellants claim that they are entitled to half of the 7 acres of land. This is the suit which we are dealing in the present appeal. This suit, the suit of the appellant was dismissed by the trial court, and then the first appeal filed by the appellant also being dismissed by the High Court by judgment, and now the appellant are before us. In the case, the appellant that are the sons of Tirakkappa, who colluded with the father and brother to deprive the appellant of their rights. Appellant contended that the suit property was purchased by their grandfather in the name of their father when he was a minor, and thus suit property was rightly not included in the 1974 partition. However, according to the appellant, their father, in collusion with his father and brother, got the suit property partition in the suit partition by compromise degree, and this has led to the reduction of the appellant's share. Well, here also reduction of the appellant's share of the property. They further argue that the compromise degree should be set aside, as they were never made a party to the suit in which the compromise degree was passed. On the contrary, the other side would argue that the appellant's interest was represented by their father in the suit in which the compromise degree was passed. It was also been argued that the trial court and High Court were correct in holding that appellant's suit was barred. Appellant's suit was barred by the principle of res judicata, as well as under Order 2, Rule 2 and Order 23, Rule 3A of the civil procedure. We have heard both sides and perused the material before us. We have heard both the sides. There are concurrent findings of the courts below against the appellant. The appellant vehemently argues that since the suit is not an ancestral property, it cannot be partitioned amongst their father. grandfather and father's brother. However, the appellants miserably failed to prove that the suit property is part of the ancestral property. After going through the records, we are of the considered view that the trial court correctly concluded that although the suit property was purchased in the name of the appellant's father, it was purchased from the family funds, and thus it is a joint family property. Since the property was taken into consideration during the partition in the year 1974. The grandfather of the appellant filed a suit seeking a partition in which the suit property was actually divided among the appellant's father, his brothers, and appellant's grandfather. The appellant's interest was represented by their father, and pursuant to the compromise degree, the appellant's father received in part of the share. Subsequently, as per the degree dated 2/8/2002, passed in suit number to filed by the appellant have also been held jointly entitled to half share of their property, of their father's share of the property. In other words, appellants were jointly held entitled to 0.5 acres of land. We are unable to understand how the appellant can claim.
Anyway, paragraph 10 is the relevant.
Yes, paragraph 10, my lord, I am going to, my lord, just.
Anyway, paragraph 10 is discussed.
Yes, let us, my lord. Yes, I'm grateful to this court, my lord.
Paragraph 10 and
yes.
then paragraph 11.
Let us discuss now, my lord. Kindly see. Let us discuss. We cannot, we do not travel much. Let us discuss the law governing a consent degree. Order 23 rule 3 of the CPC, which deals with compromise degree, reads as follows: compromise of a suit where it is proved to the satisfaction of the court that a suit has been adjusted wholly or in part by any lawful agreement or compromise in writing and signed by the parties, or where the defendant satisfies the plaintiff in respect of the whole or any part of the subject matter of the suit, the court shall order such agreement, compromise, or satisfaction to be recorded, and shall pass a degree in accordance therewith, so far as it relates to the parties to the suit, whether or not the subject matter of the agreement, compromise, or satisfaction is the same as the subject matter of the suit. Provided that where it is alleged, provided that where it is alleged by one party and denied by the other party that an adjustment or satisfaction has been arrived at, the court shall, the court, that means that court, the court shall decide the question, but no adjournment shall be granted. Object to what is the intention of the legislator? Separate suit, another round. But no adjournment shall be granted for the purpose of deciding the question unless the court, for reasons to be recorded, thinks fit to grant such adjournment. An agreement of compromise which is void or voidable under the Indian Contract shall not be deemed to be lawful within the. Thus, a reading in the above provision makes it clear that before passing a degree on the basis of a compromise, the court has to satisfy, no such ground has been taken that the agreement of compromise is illegal. Has to satisfy itself that the suit has been adjusted by a lawful compromise. Once the court passes a compromise degree, after such satisfaction, the degree cannot be challenged in an appeal, as no appeal lies against a compromise degree. No appeal shall lie from a degree passed by the court with the consent of parties. Also, a compromise degree cannot be challenged by filing a fresh suit. Kindly see, this is the position. Also, compromise degree cannot be challenged by filing a fresh suit, as there is a bar. There is a bar on filing fresh suit challenging the consent degree on the ground of the legality of the compromise. Order 22, Rule 3A, which leads as follows: a bar to suit. No suit shall lie.
Yes, that is there.
Yes. So the only remedy against, my lord, kindly see, your lordship, what I was saying, my lord, the only remedy against the compromise degree is to file a recall application. This court in Pushpa Devi Bhagat versus Rajinder Singh, 2006 5 SCC, summed up the position of law as follows. The position has that emerges from the amended provision. Well, for that reason, my lord, to cut short the matter, to my lord, so that the court is not flooded with the litigation, this amendment has been made.
Yes,
and,
3A amendment.
Yes. My lord, no appeal is maintainable against the consent decree having regard to the specific bar contained in section 96(3) CPC. No appeal is maintainable against the order of the court regarding the compromise or refusing to record a compromise in view of the deletion of clause M and no independent suit would be filed for setting aside the compromise degree on the ground that the compromise was not lawful in view of the bar contained in Rule 3A. A consent degree operates as an estoppel. Kindly see.
Yes.
A consent degree operates as an estoppel and invalid and binding unless it is set aside by the court which passed the consent degree by an order on an application under the proviso of Rule 3 of 23, Order 23. Therefore, the only remedy applicable to a party to a consent degree to avoid such consent degree is to approach the court which recorded the compromise and made a degree in terms of it and establish that there was no
After
compromise.
how many years this suit was filed from the compromise degree?
My lord, compromise, my lord, in 2016, compromise was made. In 2017, my lord, he filed.
For 1 year.
1 year. And after, my lord, 5 years in the previous suit, from 2011 to 2016, 6 years in the previous suit, again second round. And my lord, I am told, that is not on record, that on basis of the compromise, parties have sold out certain properties also.
Anyway, that's a different issue.
Yes. My lord, thus my lord, therefore, the only remedy available to a party to a consent degree to avoid, what is the objective behind? First of all, it is stated that no adjournment will be granted because the judge may be transferred, my lord, but due to delay, some complication may be made. Because the logic behind is that matter has been compromised, let the matter be dropped. One thing should not be allowed to be dragged forever. That's why there is no provision for adjournment. My lord, there is no provision for appeal also. There is no provision to file a fresh suit.
So only provision is under the
law
to
that
ask
is for recalling of the compromise degree before that court itself. So, my lord, this suit is not maintainable. That's why the trial court rightly dismissed the suit. Against that, my lord, because and above all,
because the presiding officer was the same or different.
And that is true.
So was that reason assigned that it was passed by the learned judge or passed by the predecessor?
My lord, definitely different because the next suit has been decided after so many years. So possibly they are not there.
Yes.
And my lord, the object is also that the judge who has come across the situation, he may realize whether there is some irregularity, something wrong or not. So the intention of the legislature cannot be bypassed in this way as it has been done. And my lord, the judge of the trial court is of my lord having better opportunity to examine, to follow the demeanor of the witness. My lord, I have come across the judgment, my lord. I faced one matter before Justice Bhaskar Bhattacharya and my opponent was Sudhish Dasgupta. But I took the point that when there is a difference, the opinion of the trial court will be given preponderance or more importance because the judge of the trial court had the opportunity to see the demeanor of the witness, under what circumstances order was passed. He is the proper person to, my lord, make decision. So, my lord, the trial court rightly rejected the suit, and suit is not permissible. What cannot be done directly, that cannot be done indirectly.
So after 1 year, this application was filed. Suit was filed.
Suit was filed, not application.
Suit.
Suit, regular suit. Or kindly see this story, unbelief I have done. My lord, one, the married daughter, my lord, the married sister, definitely she is guided and regulated by her husband, who is also an educated person. She filed suit against the matrimonial, against the brothers after marriage. And she is conscious about her right, how he is equipped with the law, whether she is entitled to get share of the property left by the father or not. She is quite conscious. She has fought for 5-6 years, and question of faith does not arise. The relationship, my lord, every word is to be scrutinized, and that is, my lord, the normal human behavior. Every word should be scrutinized. And my lord, that particular lawyer also not brought. That person who prepared the draft has not been brought. Well, some third person said no. Generally we make sketch in the tracing paper, but here it is on the demi paper. This is the logic. My lord, let the person who has drawn the map, let him be put in box, let him be examined, cross-examined. The truth may be revealed. Earlier lawyer may be brought. These are the things to be brought by the plaintiff himself, because burden of proof lies upon him, her. She has not discharged the burden. And my lord, kindly see in the evidence she has candidly admitted. I am showing the evidence once, just one to that.
The question is, you see, the second appeal, only the points of law.
Yes.
Those evidence.
Yes, my lord, I am grateful that your lordship has come with several civil cases, and point
scope is limited.
Scope is limited. I do.
And whatever is formulated,
yes, I do, my lord, appreciate your lordship stand. That will also minimize the matter. Minimize the.
So on the next day, you will cite some authorities.
Yes.
And conclude.
Yes.
So argue on the next day, after Mr. Chakraborty completes.
My lord, I would just pray my lord to see page 42 of the paper book. Why the learned First Appellate Court did allow my suit.
Anyway, that is also a question of law.
Yes, I mean, same as has been framed.
Yes. After your learned friend concludes, I shall see that. Yes, record and order.
Much obliged, my
lord. Mr. Chakraborty, learned advocate for the appellant, submits but could not conclude his arguments. Let this matter appear. I am giving it in the month of January.
All right.
Let this matter appear on.
As part heard, my lord.
My lord, part
heard it.
My lord, part heard.
Let this matter appear on. 8/1/2026 at 3 p.m.
I am sure your lordship is so much serious. Your lordship will go through in the meantime.
Anyway, you see,
I have seen
several matters that pending.
Much obliged, my
lord.
বলছি দেয়নি তো
কালকে জাজমেন্ট আছে
Reply again, the new character will start. It's only point of law, my lord.
My lord, it has, these points have been taken, we have to address this, my lord.
Okay.
Ghosh had on the
Now,
location
Mr.
shown
Ghosh
the
has
place.
submitted that the relief which is now sought for were not part of the plaint, amended plaint. That is the bone of contention.
My lord,
So that is
also,
inconsistent. The relief
as
sought
the
now and the
scope and nature have been shown through those judgments of the suit. That is why I want to say,
That is apparent, my lord, from the plane.
anyway.
my lord, if
Anyway, you submit.
my lord, if the plaint is considered, the plaint was filed by the wife of late Kalipodo Barik, whose estate was for administration or being managed.
Yes, Mr. Ghosh has come.
Being managed. The plaint provides for that if my lord see the pleadings of the plaint, consider it as whole, it will be seen that this suit was filed against her own sons, who are now the parties herein before my lord. This suit was made initially and preliminary for safeguarding all the properties under the estate. There is no per se a prayer or even a reference of a partition in this plaint, and a preliminary decree on partition cannot be granted
Anyway, preliminary, there is no preliminary decree.
There is no
This
preliminary
is the
decree.
admitted position.
And there is no relief sought for in the plaint which at all goes towards anything to do with a partition of the said estate. My lord, senior is here.
Yes, please.
My lord, I'll go one step ahead of my learned junior and say that this plaint, the amended plaint as it stands now, it is neither for partition nor for administration. Why do I say that? My lord, merely, my lord, making a nomenclature as administration suit does not make it an administration suit. Kindly appreciate what is the suit for. I will just give your lordship in a nutshell 1 minute, and then I will show you the paragraphs. My lord, Kalipodo Barik died. The entire dispute is revolving around the estate of Kalipodo Barik. Now, Kalipodo Barik died, leaving behind a will. And in the will, he has appointed two persons as his executor. One is Shoilobala Dasi, who is the plaintiff, and other is the brother of Kalipodo Barik, who is deceased. Shoilobala Dasi, 1990. Shoilobala Dasi, who is the plaintiff, got the grant under the will of Kalipodo Barik in 1918. Kindly makes a note of this. Got the grant under the estate.
Kalipodo Barik means the original
estate or whose estate?
Original plaintiff.
No. That is why I am telling your lordship, please bear with me.
Original plaintiff was
Shoilobala Dasi.
Shoilobala Dasi.
Plaintiff.
Yes.
Now, my lord, Shoilobala Dasi, kindly see her description. Executrix to the estate of Kalipodo Barik. Your lordship has seen. That is how she has described herself. May I tell your lordship, kindly understand what is the suit for? Who has filed the suit against whom and for what relief? My lord, the grant of probate was obtained by Shoilobala Dasi in respect of the estate of my lord Kalipodo Barik in 1918. This is a suit of 1965. My lord, administration suit is what? I will take, my lord, reference from the judgments shown by my learned senior friend. Administration suit is what? My lord, where, my lord, out of the two executors, one is not cooperating, one is dead, or my lord, the executor is saying, I am unable to
administered the estate. It is beyond me. I cannot do that. And I need the help of the court to administer the estate of the deceased. Entire estate of the deceased, to pay the Shad ceremony, to pay the creditors, and after everything is done, the rest of the property to be distributed amongst its beneficiaries named in the will or otherwise. That, my lord, with the deepest of respect, is the ambit of an administration suit. That, my learned friend's decision also says that. Here, this plaint, what does it say? What does it deal with? In 1965, Shoilobala Dasi, after getting the grant in 1918, is merely saying that my sons 1, 2, and 3, by using the properties of Kalipado Barik, they have siphoned off monies or taken the income from the estate of Kalipado Barik and have invested them in 3 properties. Property details are given. And she says that they have made conveyances, they have bought these properties from the funds of estate of Kalipado Barik. Hence, kindly come to the, my lord, prayer. What does she pray in the suit? This has been quoted number of times, but then also I am saying, kindly come to page 10 of the plaint.
Yes.
Prayer 1A, declaration that the said 84 Cornwallis Street, now called Bidhan Sharoni, Calcutta, and 8 and 12 Chittaranjan Avenue, Calcutta, belong to and form part of the estate of Kalipado Barik deceased. So the first prayer is declaration that these properties do not belong to the defendants but belong to Kalipado Barik. 1B, possession of the said premises number 8 and 12 Chittaranjan Avenue. C, declaration that the said indenture of conveyances dated 16 November 1965 is void, illegal, and of no effect. Then again the indenture of conveyance dated 16 November 1965 ordered to be delivered up and cancelled. And my lord, accounts. And 2 is administration. This only solitary prayer does not make the suit a suit for administration, because none of the other trappings which would have made this suit a suit for administration is absent. And why do I say that?
Only there is one prayer, administration of
Yes,
estate.
but my lord, merely making a prayer without any basis for it, without any pleadings for it, is neither here nor there. The dominant nature of the suit is for declaring that 3 properties are properties of the estate and getting the conveyances cancelled. That, in my respectful submission, by an executor who has already got grant and who is not saying that I cannot administer, or not saying that some other executor is not joining, hence I am unable to administer. In the absence of such circumstances, this suit as framed cannot be called as an administration suit also. Forget partition suit. That's my first argument. Second argument, there is no mention of partition anywhere in this suit, and I don't think my learned friends will also join issue there. 3, my lord, even if I take it to be an administration suit, this is without prejudice to my argument, even if I take it to be an administration suit, my lord, preliminary decree had to be passed. Your lordship has also seen that. There is no preliminary decree in this suit that is passed. Nobody's case. Kindly makes a note of this. Nobody's case that preliminary decree has been passed in this administration
An
suit.
admitted position.
Yes. And preliminary decree has to be passed in a particular form. Form number?
Order 20. Order 20, Rule 13.
First of all, considers Order 20, Rule 13, which says in an administration suit, there has to be a preliminary decree. Order 20, Rule 13.
I think my learned friend with just 1 minute.
No.
No, I What he has not taken note of that.
No, please.
I have only.
I am not
Yes,
disturbed my learned friend. He
there
will
was
clarify whenever he has the
there was
time.
no preliminary decree.
No, this is admitted position.
That's so.
Yes.
I said that.
How you can improve your case from this is what Mr.
No,
Ghosh
I
submits.
said, may remember, I said.
Whatever from the facts, you
Practice
see.
coming up that when I'm arguing, somebody is
But
going
I
to stand up
said
and
that,
clarify.
yes, there was
Clarify at your own time.
no formal preliminary decree. The object of
Then
preliminary
I will not make.
Okay, you make your you submit your written notes, give whatever you like.
Not ever will disturb my learned
Let
friend.
him complete. Whatever is there, you see, there is now no scope to improve your case or improve Mr. Ghosh's case.
This is the only point of law, man.
Yes, whatever is the position that you have to admit.
Object of preliminary decree. I wanted to say that.
Very well, you have had
Give it in your written notes.
Now you will have had
All
your
the
turn.
time it is cannot be done in the form.
Very well, whatever you submit, you have submitted, you give it in your notes.
Kindly see order 20, rule 13 once. Kindly see, my lord takes order 20, rule 13 once. Kindly see order 20, rule 13, decree in administration suit. My first argument is this is an administration suit. Second argument,
Order 20, Rule 13.
order 20, rule 13, no preliminary decree passed. Without that, you cannot take away and dispose it off. Finally, kindly see order 20, rule 13, where a suit is for an account of any property and for its due administration under the decree of court. The court shall, before passing the final decree, pass a preliminary decree ordering such accounts and inquiries to be taken and made and giving such other directions as it thinks fit. Now, my lord, this exercise has not happened. That is exactly what I was saying, that this suit, accounts, questions of valuation, questions of how much is to be, if at all it is said to be an administration suit, all these questions have to be
Only
decided.
a pendenti lite administrator is appointed on the
No.
interlocutory application. An administrator pendenti lite is appointed on the interlocutory application.
Yes, it was.
And he is
But, my lord,
continuing.
continuing. Now, my lord, if a final decree is being sought for to be passed, which is essentially the application of my learned friend, Mr. Swarnendu Ghosh, on my left, then, my lord, it cannot, my lord, jump the gun. It cannot, my lord, if I may use that expression, it cannot, my lord, be passed without a preliminary decree following it. And that is the mandate of law, order 20, rule 13. Without, my lord, adjusting the accounts, without adjusting the valuations, without passing a decree in the preliminary form, nobody can invite your lordship to pass a final decree in this form. That's my second, my lord, submission. And, my lord, in this regard, kindly makes a note, the preliminary decree in an administration suit has to be passed in form 41, 42, and 43 of Appendix A. Kindly makes a note, Appendix A, form number 41, 42, and 43. This has to be followed. None of this has been followed. None of this has happened. And that's a situation nobody can improve.
Yes, Appendix A.
Yes, Appendix A, form number 41, 42, and 43. It should be 42 or 43. Should be relevant form should be 42 and 43. Administration by specific legatee and administration by pecuniary legatee.
Yes.
Everywhere, my lord, accounts are contemplated of. Movable and immovable property, valuation is contemplated of. Sale of immovable property is contemplated of. Nothing is there in this case. Without these exercises being done, straight away, my lord, going for a final decree is not permissible under the law. Now, my lord, may I come to the decision cited by my learned senior friend? First, may I take, my lord, the decision of AIR 1935, Calcutta, page 39. Kindly takes that decision. And kindly come to page 45.
Year 1935.
35 Calcutta, page 39.
দেখুন তো ইয়েটা আছে কিনা No, I am having this one. That is 1933. That is Shiva Prasad Singh.
Yes, my lord. Lordship has that.
Shiva Prasad Singh versus Pragya Kumari Devi.
Yes, my lord.
Yes,
Lordship
yes,
has that.
yes,
Yes.
yes.
Kindly see, come to page 45. Top right hand corner is the page number. It says Calcutta, then 45. My lord has the Manupatra version.
No, this is yes Indian Kanun.
Oh, no. My lord, I'm giving your lordship the. My lord,
It's also reported in AIR 1935 Calcutta.
Yes, that is exactly. জর্জসাহেব মার্ক করতে পারবেন, বই দিয়ে তো মার্ক করতে পারবেন না।
Oh, I think
2 copies have gone.
no one other copy has.
Yes.
But kindly come to page 45 of this judgment, which is exactly what my learned friend has relied upon.
45.
Page 45 at the top right hand column, right hand, the page number is written Calcutta 45.
Yes.
But kindly see on the left hand corner, absolute bottom, nature of the present suit. Lordship has found that.
Yes.
This is what my learned friend has placed. The next question is, what is the true nature of the present suit? Mr. Das has strenuously contended that this is a suit in nature of an administrative action. Administration means the management of the estate of a deceased person who has left no executor. The object of an administration suit is to have the estate administered under a decree of the court. In such a suit, the whole administration and settlement of the estate are assumed by the court. The suit in its essence is one for an account and for application of the estate of the deceased, for the satisfaction of the dues of all the creditors, and for the benefit of all others who are entitled to, and the court marshals the assets and makes such a decree. I'm stopping here for a moment. Does your lordship find in our plaint any prayer being made that the Kalipodo Barik's estate, the dues be ascertained, the creditors be paid, thereafter the properties are to be divided? Nothing of that sort. Simplicitor, executor who has got the grant says, my sons have siphoned away money from the estate and has bought other properties. Those properties should be declared to be properties of the estate and my lord, cancellation. That is the dominant prayer and the nature of the suit. Then my lord kindly reads on. The administration consists, generally speaking, in the payment of funeral expenses, absent in this case, in the payment of debts and legacies, and in the collection, realization, and preservation and distribution of the assets. Not there. The plaint and the dominant feature of the plaint is not any of these. Then, my lord, form of plaints in such suits are given in Schedule 1, Appendix A, form number 41 to 43, Order 20, Rule 13. I showed your lordship that in an administration suit, the court shall pass a preliminary decree. Kindly mark this. That in an administration suit, the court shall pass a preliminary decree before passing the final decree, directing accounts to be taken and inquiries to be
Paragraph,
made.
that is
Page 45, right hand column.
45 right hand column.
About the middle, my lord will see forms of plaints about the middle of that page.
Yes.
In the suits are given in Schedule 1, Appendix A, forms number 41 to 43. Order 20, Rule 13 CPC provides that in an administration suit, the court shall pass a preliminary decree before passing the final decree, directing accounts to be taken and inquiries to be made. The mandate, even my learned friend's decision says so, not done in this case. Forms from preliminary decree are given in Appendix D, form number 17 and 19, and forms for final decree are given in Appendix D, form 18 to 20. None of them have been passed. Neither the constitution of the suit nor any of the prayers resemble those which are to be found in a suit for administration, And although a few of the directions that have been given by this court in its decision of 17th August 1925 as regards inquiries to be made resemble those that are given in an administration suit, in their essence and directions are widely different. So although in this suit an administrator pendentilative has been appointed, and that may resemble some of the prayers made in administration suit, that does not make it an administration suit if the in essence what has been prayed for in the suit is simply something very different. This is exactly what his own judgment says. Then I'm reading on. In para 15 of the plaint, the plaintiffs have averred A, that the plaintiffs are the real heirs of their husband and they are entitled to recover the properties left by him. B, that the plaintiff one or at any rate one amongst them is entitled to succeed to the impartable estate. And C, that the defendant has no right title to the properties left by the plaintiff's husband, but has obtained wrongful possession of them by exercising fraud, misrepresentation, and undue influence. The prayers made in the plaint substantially are declaration of title. Even in our case, your lordship saw declaration of title, recovery of possession. B, then recovery of possession of the late Raja's self-acquisition, movable and immovable, declaration of title and recovery of possession, and the entire malad prayers are set out. Then the High Court in its judgment of 17th August 1925 described the suit as a suit for recovery of possession of the Jharia Raj, an impartable estate, on declaration of the plaintiff's right by inheritance thereto. But I'm not troubling your lordship with all these. Kindly come to the bottom of the page, page 46. The paragraph starting with, this is, however, my lord has found that there is, bottom of the page,
Yes.
bottom of the page, left-hand side. There is, however, no express finding in the judgment that the present suit was of that nature. And even if there was any, we think it is no longer binding on us, having regard to the view which the Judicial Committee has taken. In another passage in the same judgment, it was said, but the suit is for recovery of the impartable estate as well as other properties, movable and immovable, of which the defendant is said to have been in wrongful possession. And there is only one cause of action, that is withholding of all those properties by the defendant, etc. Then, very important, the suit in our judgment is a suit against the defendant for wrongful withholding of possession of immovable and movable properties, and is not in the nature of an administration suit at all. So even the case cited by my learned friend, the court has not come to a finding looking at the plaint concerned that it is a suit for administration. Forget partition. It is not even a suit for administration. Similarly, I am trying to beseech your lordship to look into the prayers of this plaint, look into what is the essence of this plaint, and hold that this is not even an administration suit. Forget a suit for partition. And just because, my lord, some prayers have been passed appointing administrator pendentility doesn't make the suit a suit for administration. This is high authority. This is division bench saying this, not me. So absolutely distinguishable. In fact, it is in my favor. Second judgment that my learned friend has cited is AIR 1953 Nagpur 276. My lord has that copy. I have also given that copy today. Here, my lord, my learned friend has cited 5, 7, 11, and 12. Kindly come to paragraph 12, page 277.
Yes.
Last 4 lines were shown.
The argument of the learned advocate general proceeds on a misconception of the object, nature, and scope of an administration suit. Administration is management of the estate of the deceased person who has left no executor. Kindly see, this is not the purport of the present suit. It consists of getting in the debts due to the deceased and collecting his other assets, payment of funeral expenses, payment of his secured and unsecured creditors, payment of pecuniary and other legacies, and after deferring the cost of management, final distribution of the remaining estate among the residuary legatees or amongst heirs as the case may be. No doubt there may be strangers who claim the estate or any portion of the thereof adversely to the testator, and the administrator has to collect such estate. All this is done by an executor or executors appointed by the will, or by an administrator appointed by the court if there is no such executor. A suit for such administration of the estate of a deceased is known as administration suit. Who has quarreled with this proposition? I am not quarreling. Rather, I am saying that these things that have been mentioned in paragraph 12 are absent in the present suit. Shoilobala has not come to court and asked for ascertainment of court of the dues of Kalipodo. She has not asked for accounts of Kalipodo to be given. She has said that the three sons are siphoning of money from the estate and bought three properties. So declared those properties to be the property of the estate. How is it an administration suit? None of the trappings given even in 1953 Nagpur are present in our matter. Last but not the least, both these judgments, with the deepest of respect, say that administration suit can be converted into a partition suit, or prayers made in the partition suit can be granted. Where does it say? Nowhere does it say that in an administration suit, partition decree for partition can be granted. It does not say so. It says the court can distribute. Distribution is not partition.
Distribution is an administration.
Yes, like for example, Malad, in the will, somebody leaves behind 100 rupees to first son, 200 rupees to the second son, one house to the third son. Administration suit is
distribution.
Yes, that according to the will, the court will give 100 rupees to the
And if
first son.
distribution is not done, then administration.
Administration and final decree would be to actually give 100 rupees, 200 rupees and the house. Administration suit is not dividing the properties between the co-sharers. If the will says that three sons will jointly enjoy the property, court has to give the three sons jointly. And then they have to file a partition suit. And these judgments do not say that if the court finds after administration that partition is also necessary, partition should be granted. Where is that? Does not say so. Those are my submissions on this aspect. Now, my lord, coming back to the application made by my learned friend.
Yes.
I am saying, I don't want to repeat myself. I am simply saying.
Application by defendant number 7.
My learned friend, Mr. 7.
Application.
Two group has made. My lord, kindly see, I have only, my lord, 5 points to make, very short. Plaint I have shown to your lordship. I am saying this is not an administration suit. No preliminary decree is passed. This cannot ever be converted into a partition suit. Cannot be, because it cannot be.
You represent, that is defendant number
1B to 1F.
1B to 1F.
1B to 1.
One branch, if I may say so.
The application by defendant number 2.
2.
For the initially 2B, then they change it that
So I have shown you the plaint. I have distinguished the judgment cited by my learned friend, that this suit as framed and the prayers made by the different number 2 group cannot be granted at this stage. 3, my lord. Kindly see what is the contention made in the application, that 3 branches by way of a minutes of meeting has agreed to 3 lots of properties. My initial argument, I am reiterating that minutes does not have the details of the lots and the properties contained therein. So there is no meeting of minds, number 1. Number 2, in the same minutes, it clearly mentions that the property of Chaya cinema will be decided later. So it essentially means there was no final meeting of minds between the parties. Next, I say that as far as Mr. Dutt's client is concerned, he says that in a previous minutes, parties had agreed that at least Group C will get 3 properties which are identified. That is the argument. But as far as this is concerned, Group C is very conveniently now saying that there are 3 identifiable properties which should come to Group C, and these should be given to them in terms of the minutes of the parties, and in any event, these 3 properties has nothing to do with the other properties. They are self-contained separate properties, and different number C can take them and walk out. Now, my lord, to accept this argument, one has to see what is the stand taken by Group C previously in this suit. For that, my lord, I'm just going to show 1 or 2 things on record, all on record. First, my lord, or written statement my lord, kindly takes the supplementary affidavit of defendant number 3, Mr. Dutt's client, that has been filed in the proceedings. Kindly takes paragraph 6. This is affirmed on 31st July.
Supplementary affidavit of GA.
Yes, my lord, I'm telling you, lordship, I'm grateful to my learned friend. I'll just tell 23rd April 2025.
Yes.
It just gives me a moment's time. I'll keep it দেখলাম supplementaryটা দেখাবো kindly takes my lord paragraph 6 of this supplementary affidavit. কালকেই তো দেখলাম
Paragraph 6.
24th August. তোমার কাছে আছে ওই যেটা 23rd April. আপনার তো খুঁজতে হবে দাঁড়ান এখানে যদি থাকে
No, this is 31st July 2025.
My learned friend, I believe, has used 2 supplementary affidavits. Yes.
This is 31st July 2025.
My lord, I think it is that what we are referring is 23rd April 2025.
23rd April একটা দেখুন
23rd April টা দেখুন তো একটা সর্বজিৎ বাড়িতে 23rd April একটা থাকে July 25. That lordship has.
This is 31st July.
একবার দিন ধরে
23rd July
না Thank you, but এটা না Yes, well, paragraph that is an affidavit of 23rd April 2025. এও না ওটা হচ্ছে হ্যাঁ দেখুন ওটা দিন হ্যাঁ দিন তো kindly takes paragraph 6 দেখুন তো স্যার মিলছে কিনা হ্যাঁ paragraph 6 টা দেখুন তো মিলছে কিনা
Paragraph 6, that is, I further say that apart from the.
Yes, I further say, now who is saying this? Mr. Dutt's client. I further say that apart from the property which is under the estate of Kalipada Barik, there are other properties which was purchased between 1919 and 1965 by the sons of late Kalipada Barik which was wrongly included in the joint family properties, but actually the said properties are not within the joint family property. A list of properties which should not included in the joint family property is annexed to it hereto and marked with the letter X1. X1 কি আছে?
That is always the same.
Kindly come to X1. Which are the properties he says are outside? Kindly see
X7.
X1, the last annexure. Last annexure.
Yes.
The properties mentioned are 20 P20 Raja Bashantarai Road.
No, page 7.
Page 7, my lord.
Yes.
It is slightly illegible, but kindly see what are the properties they mentioned that which are not within the scope.
Scope of joint family property.
Yes, this is the entire suit is with according to them joint family property. Now they say which are the properties which are outside. These are, kindly see, 20 Raja Bashantarai Road. My lord, at the bottom, which is mentioned 1. From the bottom, the second last, from the bottom, P20 Raja Bashantarai Road. You
Yes, 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 yes.
Yes. And my lord, 8 8 and 12 Chittaranjan Avenue.
So these were the suit properties.
No.
Not suit property.
No, kindly comes back to
No,
the
then what is the grievance that these are not joint family
Yes,
properties?
if these are not joint family property.
Cannot be included within the
My lord, how can it be included within this suit and how can be a part of settlement? Not only this, your lordship will be astounded that there is a reported judgment on this. Kindly see.
No, the question is,
Calcutta.
it is the, if it is the case that this is not joint family property.
Yet he invites your lordship to pass a decree granting him rights to that property. Can it be done?
I have not said so, madam.
Can it be done?
This is not the new
Oh.
argument.
Can it be done?
Question is, it is included in the suit property.
If I am permitted to say,
My lord, let him hold his horses. Let me finish. Let me finish. Let him take.
This is some clarification. So, according to you, this is not a joint family property.
that is why.
Is it included in the suit?
That is not in the suit. They had mentioned all the properties, but in the written statement we made it clear that these 3 properties are the self-acquired property.
No, whatever stand you took in the written statement,
That is the stand.
have you taken it here, same stand?
Then, if that is the stand, then can he at the same breath say, for example, 10 properties are joint properties. Somebody says 11 and 12 is not part of the joint properties. Can at the same time he invite the court to pass a decree on 11 and 12? If there
I
is
have
a
said that my court
there
will
is-
record that the parties have agreed amongst themselves.
That cannot be done.
to divide the
Say,
property.
no, that's a different issue.
And this
But the question is,
belong to the joint property.
okay, that means you see, then this has to be considered and inquired. This, your stand.
And that is recorded in the division bench's order. And since your lordship is hearing this matter in piecemeal, perhaps it has gone out of your lordship's mind
because you
that
see-
this is recorded in the division bench order, which I have already annexed.
Very well. Let my
You-
lordship
you have
show it.
stated that.
So, no, not now.
Not
Let him
now.
conclude.
Very well.
Let him conclude.
Then please do not interrupt.
Yes, I have not interrupted.
Kindly
Court has asked me to
kindly come to
clarify.
AR9. I can match your voice doubly, please.
If
AR
that is the-
1973
if that is
Calcutta
the
378.
courtesy to speak in
My
the
lord,
court,
kindly,
very, very unfortunate.
very well.
This
Very
is the one point of clarification, not a,
You understand?
not arguments.
I may not give a
Because-
single answer.
Because this has to be clarified.
This is not the way one should
Habit,
approach.
my lord. Every time I argue, my lord, there will be some argument.
Yes,
to the
yes,
right.
yes. So this is the stand taken by
Yes.
Mr. Dotto
Let
in
him
his
say
written statement as well as here.
Same. And then kindly see the judgment that has passed, a recorded judgment I have handed up to your lordship.
Yes, 1973.
73 Calcutta 378.
Yes.
Same matter, this very suit.
Shoilobala Dashi.
Yes, petitioner versus Shambhunath Barik and others. My lord, I'll tell your lordship why this judgment is important. when this plaint was amended.
No, it is with regard to this suit.
This suit. Kindly see, I'm reading the whole judgment. This is an application for amendment of the plaint in an administration suit. The suit was filed in 1965 and the written statement was filed sometime in December 1965. In paragraph 14, 15, 19 and 29 of the plaint and in annexure C thereto, it was pleaded in substance that the properties being premises number 84 Bidhan Sharoni and 8 and 12 Chittaranjan Avenue were purchased from out of the funds of the estate. In the written statement, such allegations were denied and in substance, the defendant Shochindranath Barik stated therein that the properties being premises number 8 and 12 Chittaranjan Avenue, Calcutta, on which a cinema house was built, solely belonged to him and he was in possession thereof. Then, 3. The plaintiff did not take any steps to amend the plaint so long, but after her evidence had been taken on commission, she had been advised to have the plaint amended to include a player for declaration that the said two properties being premises number 84 Bidhan Sharoni, 8 and 12 Chittaranjan Avenue, Calcutta, belong to and form part of the estate of Kalipado Barik since deceased. In support of that prayer, the plaintiff now seeks to introduce by amendment the averments made in paragraph 19A and 19B of the draft plaint annexed to the petition by alleging inter alia that the said properties were acquired with the funds of the said estate although in the Benami name of the defendant and or defendants, and that the said Shochindranath Barik denies and is interested in denying that the said properties belong to. And now Shochindranath Barik is, my lord, the predecessor of the defendant number 3 group. Kindly see what he has said. And the said Shochindranath Barik denies that he is interested in denying that the said property belong to and form part of the estate of Kalipado Barik's deceased. On that basis, the amendment application has been made. Then kindly sees what the court holds. Kindly come to paragraph 6. Next page. Bottom. In my opinion, in this administration suit, this prayer for amendment should be allowed for the purposes of determining the real question in controversy between the parties. The facts were undoubtedly there in the plaint as it was originally drafted, but the question of getting a declaration for that purpose was not considered at that time, and the same ought to be allowed so that the said question may be gone into and decided at the trial, and the right of the parties herein may be finally determined. So this whole question whether these properties belong to the defendant number 3 group independently or these properties belong to the estate of Kalipado Barik are to be decided at trial. Short circuiting that, can now the defendant number 3 say, no, these properties are outside, but please pass a preliminary decree or a final decree giving these properties to me? Can that be done? With the deepest of respect, I submit. When the court has clearly come to a finding that this question, whether the properties belong to them independently or whether these properties belong to the estate of Kalipado Barik, is a question that has to be decided at trial. Without trial, how can this question now be decided, and how can your lordship now be invited to pass an order declaring the shares in these properties, dividing the properties, when the court's decision is clear? Can he go against the decision of the court which has attained finality? Nobody has challenged this.
Number 2 বলেছে কি lot C is part of the estate has been admitted. It's still pending টা বলে কি he admit করেছে.
And my lord, kindly see this affidavit of my lord in reply of Sharbojit Barik, which is, my lord, dated August 2025.
Affidavit in reply of the applicant.
Of the
Applicant defendant number 2.
Defendant number 3, my lord. 3.
Oh. Well,
Affidavit in reply to the
to your opposition.
It is supplementary.
Okay. No, affidavit in reply to whose opposition? To the main petition.
Main petition is Mr. Ghosh's petition.
To that you have filed your affidavit supporting the case.
supporting that.
I'm
And he had also filed supplementary.
no, I'm
Supplementary affidavit, yes. So affidavit in reply by?
no. Affidavit in reply by the defendant numbers 3A to 3F, 8, 10, and 11, which my learned friend is representing, to the affidavit filed by Ranjana Bari.
That means to your
My
affidavit in opposition,
Yes, they have filed an affidavit in
they have
reply.
not only filed a affidavit in opposition, but also a affidavit in reply to your opposition.
To my opposition and supplementary affidavit.
Yes,
Kindly
that is
take
what
the-
I am asking.
Kindly take the affidavit in reply. Dated someday in August 2025. দেখুন তো সর্বজিৎ তারিখ August 2025 এর কোনো reply হবে অনেক বছর না সর্বজিৎ বাড়ি জজ সাহেবের কাছে আছে
This is affidavit. This is
সর্বজিৎ বাড়ি
affidavit affirmed by the said Sharbojit Barik on 31st day of July.
No, my lord, I am হ্যাঁ 8th August দেখুন তো সর্বজিৎ বাড়ি কি ঠিক আছে দেখুন একই ও এটা হ্যাঁ kindly my lord takes paragraph 12 they admit
Yes.
paragraph 12 I say that the answering respondents, that is my learned Mr. Dutt's client, had filed a written statement wherein it was specifically mentioned that premises number 8, 12 Chittaranjan Avenue and P20 Raja Basanta Rai Road are not joint properties, but the properties exclusively belong to Shochindranath Barik's group, that is the present answering respondents. The said suit is still pending. From time to time, number of orders were passed. So they again reiterate their claim that
Now question is, see,
state.
assuming without admitting, okay, that there is a terms of settlement, but whether there is any mention of these properties.
Yes, and that so no terms of settlement can be passed in terms of
Originally-
properties which according
Originally it was in the suit, included in the suit, claiming to be the suit property by the
yes,
plaintiff.
by way of amendment,
Yes.
they opposed.
They
said-
opposed. Then thereafter, in the written statement, they have taken a stand. These are not joint
Correct.
family properties.
Yes.
In this affidavit in opposition also, they are not joint family
And
properties.
the judgment says this has to be decided at trial whether these are joint family
Okay,
properties or not.
now the question, but these were included at the time of settlement meeting.
I am not agreeing to that, my lord.
Very well. So
I'm not agreeing to that.
now the question is, Mr. Dotto,
Can
so
you-
for the purpose of settlement, only agreed that it is a joint family property. In the suit, he has taken a stand. It is
Even in the affidavit in opposition.
yes, he has taken a stand.
This
So
is after, my lord, this
so
is
his stand is only confined to the settlement. Yes, it's a joint
Lord,
family
with the
property.
deepest of respect, I am differing. Why, my lord? May I say? This affidavit is filed in August 2025. When has the so-called, my lord, agreement between the parties has happened? That minutes? 2022.
Yes, yes.
Even after 2022, he is on affidavit. His clients are saying these are not part of the joint
But
estate.
the stand taken in this settlement was different.
So he should then he has committed perjury. He is still saying that these are not part of the joint estate and the suit is still pending with regard to this issue.
But he has conceded that in the settlement.
Okay. Then he should have clarified.
So now he cannot step back.
He cannot. He after the so-called agreement, he has.
So either one has to be accepted. Either the agreement has
this
to be
this-
accepted or this one has to be accepted.
saying this has to be accepted because even the court's decision is nobody
Very well,
can
very well. That is
nobody
clear.
can relegate from this decision. And my lord, all things could have been done provided, my lord, parties agreed. Parties are not agreeing. My client is
See,
not agreeing to this whole
Either
setup. This
Mr. Dotto stand in the
short-circuit
agreement,
way.
in the compromise, either that has to be accepted or this one has to be accepted. Both
Yes.
these things cannot be accepted.
Correct. Those contrary stand cannot be accepted. That's my point. At one hand, you are saying these are not properties of the joint family properties, not within, these are my independent properties. If these are your independent properties, why do you want the court's blessing to have your own independent properties to yourself? But these are serious issues.
This was the
Serious
stand.
issues.
This was the stand by the defendant number 3. That is original defendant number
Defendant
3.
number 3,
Your predecessor.
and reiterated by his clients,
That
present
is in
clients.
and that was decided in 1973.
This was decided in,
Nineteen-
no, this is decided in
1973. Judgment of 1973?
73.
Yes, my lord.
2297.
So this point was decided 50 years ago.
Decided that this will be
But
decided.
decided at the time of anyway.
Yes.
Let us see the subsequent development.
Subsequent developments, nowhere has he said. Has he straight away, and my lord saying, my lord agreeing in a minutes and agreeing on the suit, making an amendment in his written, he could have amended the written statement and said that these are all properties belonging to the
Anyway,
estate and I want division.
So this is an admitted position. Nobody can retract.
Nobody
That one stand there and one stand
Exactly. Nobody can retract until this position is there on record. Merely, my lord, agreeing between yourselves in a closed door will not change the scope of the suit and the stands taken by you.
Okay.
That's my submission.
Page 21.
And my lord, last but not the least, I am saying, I have reiterated again and again that, my lord, without any valuation, the last valuation having taken place is 97, 98. 98, almost close to 30 years having passed. My lord, these cannot hold, my lord, the parties.
No, you
to
should
those
not take
valuations.
this point of valuation. If you are stick to this stand of this maintainability of this prayer, you don't bother about the valuation.
No, my lord, as a council, I have to also take it that your
stick to
lordship
this
may not.
principle.
No, but your lordship may not agree with me and may say that the application is maintainable.
Irrespective, if it is crores now also, you are not willing to accept that.
Exactly. But my lord, I am not so hopeful that your lordship will accept my argument on maintainability.
Okay, regarding valuation,
Valuation
it was made in 1998.
97, 98. My lord, fresh valuations have to be done. Because, my lord, over the years, one property may have appreciated in one way, the other property may have appreciated in another way. That's number one. Number two, I have already shown, my lord, that even the advocate on record of the different number 3 group in a recorded minute says that valuation has to be done and, my lord, OLT money has to be decided. That, my lord, will get at page, my lord,
আমাদের opposition 8 May.
in our opposition, page, my lord, 29.
Yeah.
Page 29.
Kindly takes my opposition, Ranjana Barik's opposition. No, the affidavit in reply. Well, this is the affidavit in reply filed by us
8 May.
against the opposition of different number 3B, 3F. এটা হচ্ছে
8th May 2025.
8th May. Ranjana Barik, 8th May. Well, lordship, well, if your lordship permits me, after I conclude, well, I would like to give a very, very short point-wise, my lord, note, and after.
No. You see, after the reply is there, I'll fix a date for written.
Yes, because, my lord, this is too much of paperwork, my lord, your lordship needs.
No, I shall give you time for filing the written notes. Otherwise, you see, if I'm hearing for the last few months, it is not possible to remember everything.
Ranjana Bari.
8th May 2025, Ranjana Bari.
8th May. Affidavit in reply.
In reply বলে বলা
So
আছে।
many affidavits, so many orders, so many.
But you see, there was honorable eminent judge who did not make any matter CAV. Even several days also, his lordship used to deliver the judgment.
আছে copy?
Eh,
My lord has
No,
the copy.
here it is only this affidavit by Sharbojit Barik.
Ranjana Bari, এই যে পেছনটা এই
Yes,
যে
this is
affidavit-
Sharbojit Barik.
Affidavit in reply by the said Chandranath Bari.
Anyway, there are many.
আছে তো? হ্যাঁ। Lord kindly takes, my lord, the annexure A. It starts from page. Kindly takes, my lord, page 29. It's scored out.
Page 29.
Yes, my lord. In fact, page 30, my lord. In fact, 13, my lord sees. my lord,
Running
kindly-
page.
Kindly looks at my copy, my lord, page 13 at the right hand top. Page 13.
1-3. Running page.
Running page 13, internal page 2.
Yeah, right.
Kindly see the second line, the sentence starting from
The property standing.
Yes. The property standing in the name of the person to be allotted to the group of the same party. The total properties to be again revalued by a panel valuer suggested by Mr. Chanchal Dotto, whose valuation will be accepted as fair valuation. The difference of valuation will be adjusted and paid to the other group from the money to be received from the sale of Maniktola Main Road property as OLT money. And when is he saying this? He is saying this in 2004. Just the page before, page 12, minutes of the meeting held on 23rd February 2004. So that reference number 3's own advocate admits that valuation has to be done even in 2004. Much closer to 97. Now we are almost 30 years down the line. And he says that OLT money has to be decided and paid to each other. Whoever gets lesser share, lesser valued property has to be compensated. That's the standard principle of partition. So even if your lordship is not with me,
That is the standard of partition if it is a contested. Not
contested, you agree. I'm not agreeing.
Yes, yes. If it is contested, that principle the court should follow.
Agree.
Yes.
Now your lordship has to decide in law whether they are entitled to this. So, my lord, today, after 30 years, properties of Group A, Group B, Group C may not be equal. And why do I say they will be equal? The last clause I'm going to show and conclude my argument kindly takes the plaint. The will of Kalipado Barik clearly says that all three sons must get in equal shares. It has to be equal.
Yes. Page.
Page, my lord, kindly takes the plaint. Internal page, my lord.
3.
3. Internal. Internal.
My sons shall get in equal share the residue which shall remain.
Yes.
That the residuary will be divided equally.
So it is when if I agreed, fine. But if I am not agreeing, then and if the court wants to do partition, it has to make sure that the three groups are getting equal. And how can the court make sure if it is getting equal? Only by valuation. Only by valuation. And valuation of 97, 98, see change now. Your lordship knows. 25 years, one property may have gone up, other property may not have gone up that much. How does the court balance? Equal shares. Can the court go beyond the wishes of the testator? If everything is kept aside, this is the will of the testator which says my sons will get equal shares.
Yes, yes. The residuary which will remain, that has to be distributed equally amongst the three sons.
How will it be done if no current valuation is made? Well, if I agreed, then there wouldn't have been so much of argument. But I am not agreeing. Then if the court has to now partition.
Yes, it is the duty of the court to see that distributed as per the share.
Shares are as per the will, the wishes of the testator. How can that be done if the court is not doing a valuation today? Then it will be acting against the wishes of the testator. That is possibly with the deepest of respect.
Suppose the building also remains, everything is disputed, only one building remains. That building also?
Yes.
That means sale.
Something may have happened to the building. The building, which was 3-storied, may have become dilapidated in 20 years.
Yes.
Previously, it was valued 3 crores. Now, it may not be valued even 1.5 crores. It so happens. So who is to determine that? Where is the finality in all this? It is very easy to come and make an application, but one has to, when there is a no consent, then one has to stand on facts and on law to get an order from court. I am saying neither on facts nor on law, this application can be allowed. But those are my respectful submissions.
So I think your reply will serve the entire purpose. Your reply.
Yes.
Your reply and thereafter the written notes of arguments.
Yeah.
So you want to start today? Very well, start.
Let us conclude. But
your lordship will kindly grant me.
My lord, my learned friend Mr. Ghosh.
And reply, as you know, it is only specific points of law and clarification.
Both my learned friends have used a lot of, my lord, documents on record, which has been shown subsequent to my submissions. In order to give befitting reply to that, your lordship will kindly allow me to refer to some of the documents which are already on record. Some documents. My lord, your lordship will kindly see the intention of the parties. Mr. Rupak Ghosh has used a phrase with regard to this matter being done in a short circuit way. Suit is of 1965. 60 years have gone by, and they feel that the process that is now being followed is a short circuit process, which goes to show that in spite of the three groups, two groups are wanting to come to a final settlement and put to rest of the dispute.
You see, what I am hearing today, 50 years ago, a learned judge heard the same particular
That is
issue.
it. That is it, my lord. But one particular group, for vested interest, is wanting to continue this suit for the next 100 years, if it is so possible. Much has been said with regard to the prayers of the plaintiff.
Yes.
Much has been said with regard to the scope, what is the nature of the suit, whether it's a partition suit, whether it's an administrative suit. My lord, let us forget as to what the nomenclature of the suit is. Would your lordship not consider as to what has happened after the filing of the suit? What is the intention of the parties? How the parties have suffered for all this while? Now that the parties are wanting to come to a final settlement, would the Honorable Court not consider that? And my lord, your lordship will kindly also see, I don't want to repeat, in my application, I have annexed two orders. My lord, these two orders out of this Honorable Court, whereby this Honorable Court has also indicated the parties that please come to a settlement. There was no submission on behalf of Group A, represented by Srimati Ranjana Barik, that no, this
page, which page?
Yes, my lord, your lordship will kindly
23?
come. Page 25 once.
Sorry, 25.
Yes.
25. No, 25.
Your lordship will kindly note the date, 5th of July 2018.
Yes.
And it is not that the question of partition was not raised. I will not trouble your lordship with the entire order. If your lordship kindly comes to internal page 2, running page 26. Now, all these points are now being taken up after 60 years. My lord, my learned friend Mr. Dutt was there. Mr. Dutt, learned senior advocate, oh, I'm sorry. Your lordship has got it, my lord, page 26.
Page 25.
6. It
Six.
starts at 25.
Yes.
The relevant portion is at page 26.
Yes.
Mr. Dutt, learned senior advocate, appears on behalf of defendant numbers 8, 10, and 11. He submits some of his clients are required to be added by substitution, referring to list of properties left by Kalipodo Barik, appearing at pages 100 and 101 of the application. He submits of 26 properties regarding which probate of will had been obtained, 4 have been sold. Persons interested have distributed the proceedings amongst themselves. So, my lord, what I'm trying to draw your lordship's attention is, after the filing of the suit, what the parties have done, whether the nature and the prayer can be molded as per the intention of the parties or not, your lordship will kindly consider, and the conduct of the parties. With the passage of time, my lord, a suit, the nature of relief can always be molded with deepest of respect, as per the intention of the parties, as per the conduct of the parties. They are wanting to settle the matter. They don't want to leave this matter for their next generation to suffer. On the basis of nomenclature, next, my lord, so far as properties under serials 27 to 38 in the list are concerned, those are alleged to be acquired by proceeds out of the estate of the deceased. Be that as it may, his submission on instruction is that the properties can be partitioned. The question of partitioning had arisen as late as in 2018. It has been all passed and recorded. They were all there. They never raised any question with regard to the maintainability, with regard to the property being partitioned at that point of time in a suit which is neither a partition suit nor an administrative suit. I put a question to myself, where were all these points then? It's a brain work of a lawyer that will come into the way of a settlement that is being made by the parties. Where were all these technicalities? They were not there. The question of partition was raised.
Where are the orders of the division bench? I think you relied on the division
lord,
bench order was there with regard to valuations.
Yes, I'll come to that. May I just, my lord, indicate the point. So the question of partition is not alien. The question of partition had since then been there. And it was passed in the presence of all the parties. None of the parties preferred any appeal. None of the parties made any application for recalling that this is a suit in which partition cannot be done. So they had accepted the proposition that partition could be made amongst the parties way back in 2018. Then, my lord, if I may just read the last paragraph. Learned advocates are requested to use their good offices. Your lordship has got that, my lord?
Yes.
Page 26.
26.
Yes, the same page.
Yes.
Learned advocates are requested to use their good offices with their clients to see that a settlement is brought about. This is exactly what we are doing. We are following the instructions, the directions of this honorable court, time and again. And your lordship will also kindly consider as why is one particular group so interested in putting a spanner in the work. In the meantime, leave is granted to the applicant to file the supplementary. That is, my lord, I'm not troubling. Then your lordship will kindly come to page 27.
Yes.
This is in 2022. Another learned judge of this honorable court. Supplementary affidavit and all given, my lord. Then the next paragraph.
Only question raised is whether in letter and spirit has there been any compromise or agreement. That is the question.
Yes.
From the record.
I'm obliged. Now, my lord, whatever has been submitted before your lordship.
You have been proceeding as per the observations made by this court, whatever it is.
Exactly.
Now, whether in the letter and spirit there has been.
The only thing is, your lordship will also kindly consider as to what has been the intention of the parties all throughout. And it is not only for a year, it's going on since 2004. I'll show that. I'll just indicate. I'm in reply, my lord. I will not trouble your lordship with the entire thing. Your lordship has given us enough indulgence. But such points I need to just draw your lordship's attention to. My lord, your lordship will kindly see the pleadings. They cannot, whatever has been submitted, cannot go beyond the pleadings. From the pleadings of the respective parties and the submissions, one thing goes to show that all the three groups have accepted the lots, subject to certain conditions. Your lordship will kindly see. Your lordship will kindly take the affidavit in opposition of Ranjana Barik, affirmed on 3rd of July 2025. How things are changing from what is being submitted and what is being pleaded. Your lordship will kindly come to paragraph paragraph 11, page 12. Ranjana Barik, my lord, Mr. Rupa Ghosh's client.
Yes.
If I may read. With reference to paragraph 6 and 7 of the supplementary affidavit, I deny and dispute all allegations and or averments and or statements thereto, save and except what are matters of record. I state and submit that the said supplementary affidavit is not maintainable and the same should be dismissed as the same is misconceived, vexatious, and malafide, and has been made in suppression of material facts. Then, most important, I further state and submit that I am not opposed to accept the proposed lot A. If I may, that is a condition, I'll come to that. If I may pause here for a moment, there is no dispute with regard to there being lot system. She is wanting to accept lot A. She does not have any difficulty in accepting lot A, but
yes.
But if parties are interested to settle the disputes fully and finally, then in such circumstances, all the properties must be properly and fairly valued by a valuer appointed by this honorable court. So, my lord, this particular line has two sections. One is that she is not opposed to lot A. If she is not opposed to lot A, she's accepting the lot system. But then she puts a condition, I will accept, provided the revaluation is made, which according to me, my lord, cannot be done at that stage because of the subsequent conduct by them itself. I'll show that to your lordship. So, my lord, from this, that the system of lots have been made.
That means all the properties means including lot A.
Yes, yes, yes. He is saying that everything again has to be revalued, which is impossible. I'll tell you, lordship, why it is impossible. But, my lord, the fact remains that she's accepting lot A. And if she's accepting lot A, she's accepting lot B and C automatically. So she is also accepting the fact that there has been a system of lot A, lot B, and lot C being done by the parties. This is an admission. She has sold. I'll come to that. I'll come to that. Now, my lord, the condition that she will accept upon revaluation. What has not been brought to your lordship's notice is so much has been said that from the distribution of lots from lot A, she has already sold the property. She has been utilizing the proceeds. She's kept it for herself. I'll show it from the records. Having had done that, I put a question to myself, can the property be revalued? Can any of the properties be revalued? Then your lordship will kindly come to my lord. Next, my lord, your lordship will kindly come to the affidavit in reply of Chandranath Barik, my client, dated 23rd of April, 2025. He has already sold it.
Chandranath Barik.
Chandranath Barik, my client. Yes. 2025. First, I'll take your lordship to page 15. This is of 2004. So much has been said with regard to the judgment of 1973. So much has been said with regard to prayers of the plaintiff. But the subsequent understanding of the parties, the subsequent conducts is not being brought to the notice. So much has also been said with regard to Mr. Dutt's client, having said that it is not a joint property. Thereafter, they have conceded to it. Lordship will kindly see. This is a very important minutes. Minutes of the meeting held on the 23rd of February 2004 at 4 p.m. at such and such. Present, all the three groups are present. They cannot say that it has been done behind their back. (2004), my lord, the date is very important. After long discussion, it was decided as follows. All the three groups have decided. The following properties to be allotted to the group of Sachin Barik, that is Mr. Dutt's client. Properties are there, 3 properties. So they are admitting the fact these properties are joint properties. And accordingly, it has been allotted to them. Then, my lord, the next paragraph. The rest of the properties to be divided into 2 lots, and 1 lot will consist of properties around Chaya Cinema, and other lot will consist of properties around Darpani Cinema and properties situated on Vivekananda Road, Calcutta. The residential house will be divided into 2 equal portions. Then, my lord, I'll not trouble your lordship with the entire thing. Your lordship will kindly see the lot system. Page 16, internal page 2. First paragraph. Further, it is decided that group of Saroj Barik will be allotted the properties around Chaya Cinema and are ready to pay the cost of development, such and such. My lord, group of HON'BLE Barik, properties have been given. Next, if your lordship kindly turns, very important thing is internal page 3.
Group of HON'BLE Barik.
Yes, my lord, that is Mr. Rupa Ghosh's client. Then very important and interesting point is page 17, internal page 3, item 17.
Yes.
Darjeeling House.
Which is disputed by Mr. Dotto to be not as joint family property.
No. It is all joint family now. All
Oh,
joint
in your
family.
affidavit.
No, they are not this property.
Okay, there's some other Darjeeling is.
The property has gone to Mr. Rupak Ghosh's client and he
Mr.
sold it.
Mr. Dotto was saying with regard to P20, but that has also come within this, that has also become a lot. What has been said is what they were claiming to be their single property has been given to them in their lot. But that has also been considered to be a part of the joint estate. Now, my lord, the interesting part is this item 17, Darjeeling House.
So when was this sold? After this agreement or before?
After this, that is exactly what I want to draw your lordship's attention to. Darjeeling House has fallen in their lot. They've sold it. Proceeds they have been enjoying since 2016. Having had done that, can they now turn around and say, I am not accepting, I want revaluation? I put a question to myself, what will happen to the Darjeeling property, valuation of the Darjeeling property then? I have said that, 2016. What will happen to that property's valuation? She's crying hoarse about the revaluation of all the assets. Has she come forward before this honorable court and has been true enough and honest enough to say, I've sold it and I've been utilizing?
Darjeeling House is located at Darjeeling, yes.
Yes. 2016, she's enjoying all the proceeds. She has not distributed the proceeds with anyone. So this conduct of hers shows that she has accepted the lot and she has acted in terms of the lot also. And that, the Darjeeling property, is that of a joint property that will come from the deposition of her father. That is at page 22. Mr. Rupak Ghosh was crying hoarse with regard to the trial. This is what has happened in the trial. It has all been adjudicated. Now it's the only intention to drag along for the next 100 years. My lord, your lordship will kindly see examination chief of Shambhunath Barik, the father of Ranjana Barik. What is she saying? What is he saying? Question. Is there any property at Darjeeling lying in your name? Answer is yes. The estate Kalipada Barik purchased a house in my name. Then next question. When was it purchased? Answer is around 1940. Then do you know the P20 CIT scheme? Yes, that is the one that they were claiming. Whose property is that? The estate Kalipada Barik purchased the property, yes, in the name of Shochindranath Barik. Next, according to you, who is the owner of P20 CIT scheme? Answer is this property also belongs to the estate of Kalipada Barik. So, my lord, the father of Ranjana Barik, Shambhunath Barik, in his examination in chief, has admitted the fact that Darjeeling property is that of the estate. And this Darjeeling property has gone into their lot, which they have sold by claiming that the said property is their personal property, which will also appear from page 23. I put a question to myself, after this, all this submission, so much of submission for so many days after all this, can they approbate and reprobate? Are they not stopped? Then page 23, my lord, your lordship will kindly see. This is a letter by Ranjana Barik and her group, Rupak Ghosh's client. It starts at page 23. I will not trouble your lordship with the entire letter. It is being addressed.
Yes, for the mutation purpose.
It is being addressed to the chairman, Darjeeling Municipality Mutation Department, Darjeeling. And what is she saying? Page 24, my lord, the first line. I'm not troubling your lordship with the entire thing. As aforesaid, Srimati Ranjana Barik and we, the undersigned, are the present joint owners. She is the owner. We have accepted that. 2016, she sold the property in 2016, her allotted portion. Does it not put a rest to everything? P20 has been given to, it has fallen in their lot, Mr. Dutt's client's lot. They have sold P20. They have sold it.
Oh, Mr. Dutt says that let it be settled, so far he is concerned.
Yes, I'll come to that. I'll come
Not
to
only
that.
me, not only, if it is settled in my favor, it will be settled in favor of
It
all.
cannot be piecemeal, my
It
lord.
cannot be peaceful.
The intention by the parties has been that there has to
Yes,
be a
if
rest.
all the parties accept Mr. Dutt's share, then
I have sold my share,
yes.
portion of my property, and they have also sold some portion of their.
My lord, when two parties have sold from two
We are ready
parties.
to pay wealthy money.
No, wealthy money now in 2016, you will sell. You will claim yourself to be the owners. In 2025, you will say, I'll give wealthy money. This is not child's play, my lord. We want it to be settled for once and all. This is not your child's play as per your whims and fancies.
Anyway.
This cannot go on.
So this is the factual position, admitted position.
Yes, I'll come to my lord. Yes, I'll come to that. Now, my lord, if your lordship wants, I'll continue, or shall I come back on the next occasion?
It is better to
10 minutes more if you want. Can you conclude today?
I cannot conclude today.
tomorrow, my lord, kindly keep.
No, I'll not. No. My lord, my learned junior has just got married. He will join
Friday.
next Tuesday. Then if
Friday.
it can be taken up next Tuesday. I don't want to deprive him.
No, because if I keep it on Friday, I can do one thing.
Next
Anyway, if I
Tuesday, my lord, can it be next Tuesday? He'll join by Monday.
So the question is, if I make it Tuesday, can you come with your written notes, everything?
My lord, he will join on Tuesday. I'll take 1 more week's time. He's just got married
Because you
last
see,
week.
last 2 weeks, this bench may not sit
Oh.
due to circuit. That is the question.
My lord,
So anyway, I'm keeping it on Tuesday.
Your lordship,
If I'm unable to complete it this
then
year,
my lord,
first week of January, it will be completed.
My lord, one day.
বুঝেছি কিন্তু আমার যে নোটটা লিখছি আমার ওই জুনিয়রটা লিখে রেখে নিচে বিয়ে করেছে
নোটটাও রেডি করতে হবে। Yes.
Tuesday মানে lordship kindly keep thereafter will.
Learn it.
My lord, one thing, my lord, kindly keep it in mind, although I should not, in the midst of the submission, I should say, Mr. Ghosh was all the time arguing preliminary decree.
Whatever it is.
So just remember kindly, Mr. Rupa Ghosh, preliminary decree means what? Preliminary
Anyway,
decree.
that is an admitted position. There is no preliminary decree.
No. Preliminary decree means declaring the share of the party.
Yes.
That is the whole meaning.
That is an
And
admitted.
here
Here
the
that is
parties have agreed their share. So
That is my prayer in the petition.
that is the prayer in the petition.
I have not wanted final decree. It cannot be because the commissioner
Recording the partition.
of partition has to be appointed with regard to the partitioning of the dwelling house.
Decree has to be passed after valuation is done. Our stand is first the court has to see if the valuations are correct.
Anyway, that you state it clear in your written notes.
I will. Having had acted upon,
Learned advocate,
Valuation.
the parties are present. Mr. Ghosh submits with regard to his reply, but could not conclude the same. Let the matter appear on 9/12/2025.
I'm deeply obliged.
আচ্ছা 9 তারিখে অ্যাপেলেট সাইটে দেখুন তো কিছু আছে কিনা কোনো ফিক্স ম্যাটার।
কোনো জজ সাহেব সাফিসিয়েন্ট ইন্ডালজেন্স দিচ্ছেন আর কি বলবো।
Your junior will be available on 9.
Yes, my lord.
2 PM ফিক্স আছে 9 তারিখে। 3 PM কিছু নেই। 2 PM এ কি ফিক্স আছে? সেকেন্ড অ্যাপিল। Shall I keep it at 4 PM?
After 3:30 always is a very risky.
আচ্ছা ঠিক আছে, let this matter appear on 9/12/2025
12 noon.
at 3 PM.
At 3 PM.
I'm deeply obliged. I'm deeply obliged.
Yes, if you can conclude well and good, otherwise what can be done?
Yes, I will come.
Month of January.
I will come.
No, we shall prepare the.
Because our time has to be given for all the parties to submit written.
Yes, well, that will take some time. Your lordship has been so indulgent with us, my lord. We cannot quite expect anything more.
Anyway, let us see whether some justice can be done.
We will have justice. We have.
See, this 50 years ago, this decision again Whatever
50
is heard
years.
by the judge 50 years ago,
Yes, my
my,
lord.
my predecessor.
We are standing in the same position.
Yes. So I have to hear this.
That is the only intention of the parties
End of this
to put an end to this
Kindly
litigation.
put an end of this.
Anyway,
Already third generation.
let us see at 3 p.m. how much we can conclude.
Yes,
Yeah.
grateful to your lordship.
এটা এই দুটো নিয়ে নেবে